Lordship, one item number is Lordship has fixed this matter at top of the list, Lordship. Lordship, my friend Vigogo is appearing in this matter. Lordship, due to some medical urgency, Lordship, he will not be able to remain present in this court in the first half, Lordship. So may I pray for Act 2, Lordship, of the Ice, Lordship.
Pending matter, allotment of land matter. Premium also calculate this matter, but not allotted.
What is the urgency?
Urgency, it was last listed 19/11/25.
So, what is the urgency?
Urgency means, my lord, they are disturbing, my lord. As it, allotment has not given to you. Allotment has not given to you. They are disturbing, my lord. That's why, my lord.
You have made that statement.
Yes, my lord, given there.
Okay. Tomorrow?
Any date, my lord, sir.
Then there is no urgency, any date.
Tomorrow, my lord, there, my lord.
My lord, eviction matter, my lord, may I pray for today, my lord, at 2 p.m. File, my lord. Obliged, my lord.
My lord, the land allocation matter, acquisition matter. And pending, it is last listed on 23 June 25. So typically it is listed on Friday, my lord. If it is possible. Friday.
Land acquisition.
Land acquisition, compensation has not been given. Solicium and interest is pending.
Any other day, next week, date at all.
Lordship, land acquisition matter, for listing. Lordship on land acquisition matter.
Motion,
Lordship for order.
orders, why? Why orders?
Lordship,
Not for admission?
Lordship, it was listed earlier, but unfortunately, it has been left over.
Has been listed as?
On-
Well, next week or deliver. Admission. Yes.
Taking for a list of WPC for admission, it was last listed on 16th of December 2025. It's listed on 20th of February 2026.
Why?
So it is a land acquisition matters, and due to its urgency, the petitions are not denied compensation.
So what is the urgency?
Urgency because now after so days it has not been.
Have they filed the affidavit? Have they filed affidavits?
It is in the admission stage.
No, have they filed affidavits? Government filed affidavits? The next week.
I can take for motion.
What is it?
Eviction matter. The eviction notices 133. On tomorrow, we're asked to submit the presentation. We'll submit the presentation tomorrow. And next day, 19 is the date, ultimatum date to vacate the land.
Disposed. Waiting. Itu mo he order to site plan dito. Ayan ito here. Eviction was on the AR mo yan. Yes.
That civil council was supposed to appear through video conference. Okay.
In terms of the last token note, I have received the instruction. এটা আছে।
Yes.
Now, Mr. Gupta, have
My
you
lord.
mentioned this in your affidavit?
My lord, it has not been mentioned, my lord.
You do one thing.
My
If
lord.
it is not mentioned, file an additional affidavit,
My lord,
giving them, you file within 7 days
My
or
lord.
how many days?
you can file it immediately, my lord.
You file it immediately
Ma'am.
whenever it is
Ma'am.
possible for you. And let them reply, give them 3 days time to reply, and then we take it up next week.
My lord, my lord,
Huh? We understand that there is urgency in the matter.
my lord.
And what you have stated, I think it is very relevant out here
My
for the
lord.
purpose of the instant case.
My lord.
But on this document, if I dismiss his petition,
My lord.
tomorrow a question will arise that they have not been given the
My lord,
opportunity.
my lord, my lord,
Okay.
my lord.
Mr. Pursuant to the order passed by this court on 6/2/2026, Mr. H. Gupta, the learned CGC, had placed before this court a set of instructions. Have placed before this court an instruction dated 13/2/2026. The said instructions are kept on record and marked with the letter X. It is the opinion of this court that the contents of the said instructions being not already, having not been incorporated in the affidavit in detail, affidavit filed by the respondent authorities earlier in detail, such the contents thereof be placed by way of an additional affidavit so that the petitioner be given an opportunity to reply to the same. Mr. H. Gupta submits that the affidavit would be filed by 20. You can file it by 20. Today is 17.
My lord, my lord.
By
Ma'am.
20/2/2026, liberty given to the full stop. Full stop. The liberty given to the respondents authorities to file the affidavit, additional affidavit by 20/2/2026 by providing advance copy to the counsel for the petitioner as well as counsel for the private respondent. Full stop. The counsel for the petitioner would be at liberty to file the reply on or before 18th of February 2026. List the matter on 19th of February 2026 at the top of the list for final disposal.
Today,
Probably getting the weeks wrong. Today is 17th. 17th of it.
Oh, no, it will be 26th.
my lord,
He will file by 20 and he will be 26.
my lord.
Yes, all matters. Argue.
Yes, it's only few minutes in the time to be told.
Okay, let him argue.
Lordship, for me also short prayer of accommodation. Mr. Bigogo is arguing this matter, Lordship. He is not available on the first half, Lordship.
What is being said to that? Such an old matter, it doesn't look nice. There's no stay. Yes, argue, were they?
The entire tax. We have paid the entire taxes.
There's
So
nothing remains. Then
it has to be set aside.
why?
Because the entire amount is recovered from us. It's not that we paid
Why there are three repetitions?
for different assessment years.
Okay. Okay, argue which one you are arguing,
Any matter, first matter.
whichever you feel like. Which one is comfortable for you? Which one?
686.
768. Okay. Argue, what is the ground on which you are asking? Okay, just narrate the facts. What is it there?
Lordship, in this case, Lordship, what had happened for the assessment year 2008-9? Lordship, I had filed my returns claiming I'm Lordship dealing in selling of medicines. So Lordship, I had claimed free supply of medicines. Free supply of medicines. Lordship, on free supply of medicines, there is no tax. Because we have not taken any consideration, it has been Lordship distributed freely. So Lordship, therefore we filed our returns, but thereafter Lordship, after accepting our returns, they passed an order of reassessment, the authority. The main allegation was that Lordship, the order of reassessment is at page 33.
Page
33.
36.
33, Lordship. The relevant portion will be at page 35.
33 is only a, this is a notice.
Page 35 is the relevant part, Lordship.
35.
The assessment, 35.
Okay, yes. The case of the dealer was taken up for turnover escaping assessment following the detection of audit report that the dealer had sold free medication.
Free medicines worth of so and so on MRP basis at the first point of sale. So, however, the dealer did not pay the tax as per government notification. The dealer is liable to pay taxes.
Okay, so notice were issued to you on certain audit objection and you did not reply.
We had supplied the medicine free of cost.
Understood, but therefore they gave you an opportunity to kindly explain. Kindly see 24/9/2015. The case of the dealer was taken up for turnover escaping assessment under section 40 of so and so, following the detection in the audit report that a dealer had sold free medicines worth so and so on MRP price at first point. This is an allegation of fact within the state. However, they did not pay anything. Now, your case is that we did not sell it. That's your case. You were given opportunities by issuing 2 notices.
There was issued to me, but Lordship, I received it delayed. But Lordship, that is not the question because.
So once delayed is okay. Second time, did you approach them that look here, I have received it late. So kindly, I want to reply. Because they gave 2 notices.
Because Lordship, before the revisional authority, I had placed everything.
Forget about the revision authority. Against revisional authority is different. Revision is you are filing a revision against an order passed in an reassessment order. So this reassessment, therefore, it was reopened and you were imposed.
Yes.
Now this is happened. Now what has happened?
Page 40 is my the revision petition, which had the order of the revision.
Page, where's the order? Page,
Page 40.
Petitioner is directed deposit 15%. Okay, order. 3 revision petitions were filed by so and so. The reason so and so, the superintendent reopened the taxes, but aforesaid taxes were liable on the first point of sale on later advance. Into the MRP value. So this is a notification issued on 11/10/2006.
This is for levy of tax on the medicine. Lordship, we kindly see the notification.
It is at page 41.
The medicine should be taxable under the Assam VAT Act at the first point of sale in the state of MRP basis. And whereas it is common practice in the medicine trade to offer free units on sale, and whereas it is also a fact that this type of free units are ultimately sold by retailers to the consumer against the price consideration. But I have annexed that notification also.
Listen, read it.
And whereas the tax so collected on free supply should go to the coffer of the Lordship, and whereas such retailers would be collecting tax on such sale. I am not collecting tax. Lordship. We are
Wait.
saying that
No,
if I
madam, I understand that. Kindly read now, therefore.
and whereas now therefore to obviate the difficulties arising out of such situation, in exercise of power conferred by so and so, the governor of Assam is hereby pleased to direct the free supplies at the first point of sale in the state on MRP basis shall also be deemed to be the sale of such goods, and the dealer shall making such free supply at the point of first sale in the state shall calculate and pay tax on MRP of such goods.
So you are therefore, as per the notification, required to pay, irrespective of you make the free supplies or not. Then,
Being aggrieved by the aforesaid orders, the dealer had filed 3 revision petition for this period, being the facts and circumstances of all the 3 revisions are similar. Revision petition are disposed of by single order. Therefore, the initially the petitioner had filed a statement containing grounds of revision along with revisions, which contain 8 different grounds. Later on, filed 9 different grounds. Additional grounds are basically legal grounds. Gist of grounds are as under: levy of tax on free distributed supplied medicine is unlawful. Opportunity of being heard was not provided. Being there was no consideration for such free supply, no tax is leviable on such supplies. Levying tax on MRP value is not supported by the Constitution. Levying on tax on free supply of goods on assumed turnover is unlawful. Interest on such tax is also unlawful. The learned counsel submitted that effective opportunity of hearing was not provided. From the result of record, it appears that 2 notices have been issued the learned by the superintendents, and on failure of the petitioner to respond the said notices, the order was ex parte. I don't find any merit on the said ground of providing opportunity of being heard or of not following the principle of natural justice. As regards levying of tax on MRP value of free distributed goods, learned counsel has submitted that levying of such tax on notional assumed value is not constitutional. He referred to the apex court decision in so and so and submitted that in the said case, similar provision for levy of tax on the first point of sale of drugs, medicines was to be charged on the basis of MRP published on the package, which was challenged by a brief petitions, and the same has been allowed by the High Court of Rajasthan. The state moved before the apex court challenging the decision of the High Court of Rajasthan. He further submitted that the same medicines were distributed by the petitioner free on discounts to the resellers. The tax in this instant case has been levied on the basis of so and so, which has been issued under so and so. The state section does not empower the government to issue such a notification, resulting in additional tax liabilities on dealers. He further argued that such notification speaks about that free supplies at the first point of sale in the state on MRP basis shall also be deemed to be the sale of such goods, whereas as per settled law, VAT cannot be levied on deemed sales, except the deemed sales as prescribed under clause 29A of Article 366 of the Constitution of India. He then argued that even if it is assumed that tax is leviable, dealer cannot be made liable to pay interest as because so and so, so and so. Lordship, final argument was, I have considered the arguments and could not find any merit in the arguments as regards the act is concerned. Explanation so and so read with fourth schedule, it is clear that in case sale of medicines, tax is leviable at the first point of sale on MRP value of goods. So the question regarding medicine which has been distributed free along with other medicines. The aforesaid notification is very clear, and accordingly free supply at the point of first sale in the state on MRP basis are deemed to be the sale of such goods, and the dealer making such free supplies at the point of first sale the state is liable to pay tax on MRP of such goods given free. I could not find any demerit in the aforesaid notification as regards the so and so aforesaid judgments. Facts is different and ratios are not applicable in the cases.
so therefore, the problem arises with this notification. Because by the orders of assessment are okay. Because this is done as per law. Now the question of reassessment as well as the revision is also okay, because this is done as per law. Now the question is whether by way of this notification, which is at Annexure 3, it can be said to be ultra-virus the provisions of the Assam Value Added Tax Act. If this is held to be bad, consequential orders will follow.
In the affidavit also they follow the same stand. They say that since retailer will ultimately sell and collect tax. So Lordship. that's
It
why
is for the purpose of removing the mischief.
Yes. Lordship, I rely on the one judgment, Lordship, of the apex court exactly on the same issues. In the state of Rajasthan, Lordship, similar provision was there.
Yes.
Lordship, this is the Lordship, Supreme Court judgment, Lordship, reported in 2006, 6 STC 773. It is also reported in Lordship 147 STC 542. State of Rajasthan versus Rajasthan Chemists Association.
Yes. Then-
Lordship, I rely on paragraph 41 onwards. These cases.
Now, tell me, under what provision you are giving free of charge?
Lordship, because the Lordship, when it's a Lordship common practice that whenever we distribute the wholesaler distribute the medicines, Lordship, they have to give some free of charge also medicines. They cannot, Lordship, it is a common practice all over that they give sample pieces that you for distribution so that.
But is it marked as sample?
Lordship, it is marked. That is what in the affidavit also it is written that yes, we have given, and it is an admitted position that we have given it for as a sample piece free of cost.
Sample piece is a different thing.
Yes, sir.
But the question is, whether it is sample is free has been mentioned in the cover of it.
Yes, sir.
Is it? How do we know?
Lordship, in our paragraphs, in our affidavit in opposition that has been filed by us, specifically in paragraph 6, we have specifically stated that these are not free samples which have been given by the petitioner.
So unless you don't give it, you may say so, that okay, these are free. First of all, you being the authorized distributor, you must be having an agreement with the company
Yes, sir.
for whom you do it. Just for example, let us take the example of a company by the name of what? Edila? Torrent, whatever. So with that, the distributor, you have an agreement.
Yes, sir.
Now, if the company has to provide, or you do it, or is it your practice of a sale that there must be something that, okay, if we take 10 pieces, we give 2 pieces free. If that is a thing, then it forms a part of the consideration because of that, they are purchasing from there. But if it is a case that no, we are giving free samples for whatever maybe, it is nothing to do with anything, but we are giving free samples out here for the purpose of use to be sent to the doctors or some hospitals. It is being given out there. It's a different thing. But how does it land to the retailer?
After
Because the retailer cannot send it. The retailer has to sell it.
yes, sir. The retailers are selling.
So if the retailer is, so the fact that the retailer is selling it, just for example, I remember that in certain, some pieces, it is not normally given to the doctors, where indeed it says physician's sample not for sale. So these are different. This cannot go to the retailers. And if it goes to the retailers, means you are at fault. You are distributing it to the retailers. But how on earth it goes to the retailers free of sample?
In our, Lordship, whatever the pieces which we distribute, it is written local taxes extra, which shows that.
So local taxes extra means you have to pay. But my question therefore is, normally if it is free, just for example, those physician samples free, which is goes to the doctors, it is okay. But how does it land in the hands of the retailers? If it goes to the hands of the retailers, means the retailers cannot retailers cannot distribute free.
Retailers might say.
So then what is wrong?
This is what-
Problem is there. I would have understood in any other case it's okay, but the moment you have the, and it is normally given by the companies who have their representatives, they put these samples out there and give it out there to the doctors, and these are physician samples not for sale.
Day by day. This is not if we are talking about 2000.
No, now what you are doing? You are saying that okay, if you take 10 pieces, we give 4 pieces free. So you are saying now that as regards these 4 pieces, it's given free, so don't charge us. We are not liable to pay. But the fact that the first point of sale has been made out there, it is a sale. It's a different thing. You may have an arrangement with the retailer saying that, okay, the retailer concerned, he may get it. Now let's see Rajasthan judgment, how the Supreme Court deals with it.
Yes.
Finally come to paragraph 4.
Yes. Primary challenge before the High Court was on the ground that it takes into account an artificial amount of turnover for the purpose of tax on sales of goods. The tax on sale must be leviable with reference to something relating to taxing event, the sale or purchase of goods which become subject to charge and not divorce it. With reference to NT 54 of the second list of the second schedule of the Constitution of India, it was submitted that the expression tax on sale of goods used in the said entry means tax on sale of goods as defined under Sales of Goods Act so and so, as modified, extended by clause 29A of Article 366 of the Constitution of India, inserted by 42nd Amendment so and so. Single point tax is leviable on sale of medicine as per notification issued under the Act. Factually, the first point of sale in the state of Rajasthan in most cases, which extracts levy of sales tax, is by the wholesale distributors to the retailers and not by retailers to the end consumers, where alone MRP can be charged. Under the so-and-so Act and the provisions of drugs so-and-so Act by the central government, under Section 3 of Essential Commodities Act, in short, the so-and-so, the maximum retail price is determined in the case of scheduled formulation only. On the other hand, MRP is required to displayed on the label of the container as well as package in respect of all drugs, whether scheduled or non-scheduled formulations. Mention of price on the package under the provisions concerned is MRP and not the price necessarily or actually charged at the end sale for any transaction of sale of medicine in the state. The first sale within the state, which alone is taxable, is in reality at much lesser price than the MRP printed, and the same is paid or payable on contractual basis. Under the control and the margin at which the medicines are to be sold to the retailer has been fixed at a minimum level. This is to say, unless otherwise permitted, a formulation has to be sold to a retailer keeping at least 16% margin in the case of scheduled drugs. Thus, by devising the aforesaid legal fiction for deeming an artificial sale price for levy of tax having no nexus to the taxable event, that is transaction of sales of goods at a money consideration paid or payable as defined in the Sales Tax Act, is beyond the legislative competence of the legislature in the state, and therefore the provision is ultra vires. The state, on the other hand, took the stand that what is to be measure of tax on sale is within the domain of state legislature. Under the impugned provision, tax is levied on a completed sale within the meaning of Section 4 of the Sales Tax. However, in what manner the charge is to be levied is a matter of detail, which can be worked out by legislation. The fact that MRP is to be determined statutorily and the state legislature has taken into account the fact that actual consideration at the first point may be lesser than the maximum retail price, it may be charged ultimately from the consumer at the last point of sale, as provided for abatement by MRP by reducing therefrom the sum at the prescribed rates of state abatement for the purpose of levy of tax. Provide sound basis for uniform liability in the state on such transaction. The levy of tax cannot be said to be wanting in excess with the taxing event. Therefore, the impugned provisions and the notification cannot be said to be ultra vires any provision of the Constitution. It was, however, not disputed that, but not for taking MRP as a basis to provide measure of tax. No fictional price can be fixed as a measure of tax on the sale of goods. The High Court, on analyzing the provision in great detail, came to hold as follows. If section 4A is designed to bring a levy into existence, which is divorced from the sale, subject to tax under the act, it falls with the legislative competence under section entry 54 of list 2. So also notification annexure 3 to the extent it is intended to levy tax on first point of sale with reference to price which could be charged in respect of a subsequent sale which has not come into existence. At that time, liability to tax arose and is determined ex hypothesis. However, the perusal of the language of section 4A and the notification issued thereunder by itself does not show that it applies only in case of sales to be taxed at first point. In case the levy is on the last point and the maximum retail price is to be fixed and published under any statute, whether instead of determining the price actually charged in each case fixed formula is provided by the enactment which has correlation with determining price by keeping in view the provisions of section 9 of Sales of Goods Act. Whether the provision still falls beyond the scope of entry 54 has not been the subject matter of contention. In this case, and therefore we have not been called upon to decide, in the absence of any contention having been raised, it will be hazardous to comment upon the validity of provisions of section 4A in isolation and the notification issued thereunder in its entirety. In view thereof, we confine our conclusion and hold to the extent that tax on first point of sale of drugs, medicine, or any formulation of or any matter and other commodities by a manufacturer, wholesaler, distributor to retailer where MRP is published on package, measure to which such rate is tax is to apply cannot be with reference to such published MRP, which is neither charged nor chargeable by the wholesaler from the retailer, whether the tax is charged on sales or on purchase by the parties to sale under section 4A by and notification. Additional tax collected with reference to the measure provided under section 4A by the wholesaler to the retailers at first point shall not be refundable to the dealers. In case the additional tax charged has not been transmitted to buyer, excess tax paid may be adjusted against future liability under so and so or any other dues to the revenue under the Rajasthan Tax Act. In support of the appeal, learned counsel for the appellant submitted that there is a source of power of the state to levy tax under Article 246 read with entry 54. A plain reading of the entire entry clearly demonstrates that tax under the state entry can be levied on the event of sale or purchase of goods. The said entry nowhere requires or mandates that the same can only be on the sales price of goods. Strong reliance is placed on the decisions of Andhra Sugars and Ganga Sugar to contend that the Constitution empowers the state to levy and collect tax on the happening of taxable event, and thereafter the quantum of tax to be levied and the measure on which the same can be levied is necessarily left for the state to decide. Per contra, learned counsel on the respondent submitted that High Court decision is on terra firma. On an elaborate analysis of the legal position, the decision has been rendered and needs no intervention. It was pointed out that the decisions in so and so were rendered on the peculiar facts of the cases and they nowhere depart from the normal principle that tax is to be levied on the sale price. In order to appreciate the rival submission, a few decisions on this court which throw vacant light on the issues involved need to be noted. In fact, the High Court has referred to many of them. Number one, STO versus Buddh Prakash arose under UP Sales Tax Act. In that case, the issue related to levy of tax by the assessing authority on the turnover relating to forward contract. The SSC had challenged that the imposition of sales tax on forward contracts was ultra vires the power of state legislature. The UP Sales Tax Act had been enacted by the provisional legislature in terms of legislative power conferred in the Government of India Act under entry 48 in list 2 of the 7th schedule of the said act. Under section so and so, a sale was defined to include forward contracts. This court upheld the challenge by holding that the power conferred under entry 48 to impose tax on sale of goods can be exercised only when there is a sale, under which there is a transfer of property in the goods, and not when there is a mere agreement to sale. The state legislature cannot, by enlarging the definition of sale, by including
Let us skip these parts.
Yes,
That is not necessary. Let's come down to para 19.
the state legislature does not have the legislative competence to give the expression sale of goods extended meaning and to enlarge its legislative field to cover those transactions for taxing which do not properly conform to the elements of sale of goods within the sales tax. Tax on value of the materials used in construction of building was held to be ultra vires. The decision in so and so also relates to imposition of tax on supply of materials used in building and held the court. And this court followed its earlier decision in Ganon Dankarli's case and held that the expression sale of goods in entry so and so of the 7th schedule of the Government of India Act has the same import which it bears to the sales tax.
Madam, then we come back. Let us not trouble ourselves with Ganon Dankarli. Then let us come to paragraph 24. In Union of India, was it the expression?
With International Limited. The expression subject to tax, measure of tax, and nexus between the two has been succinctly analyzed. The decisions arose in the context of Central Excise and Salt Act. The controversy was what should be included in the measure of computation of liability and what fell outside the scope of measure to be excluded from consideration. Referring to a large number of decisions of different courts, including some of the decisions we have referred to about, the principle succinctly stated in so-and-so was approved by observing as follows. Another principle for reconciling apparently conflicting tax entries follows from the fact that a tax has two elements: person, thing, or activity on which tax is imposed, and the amount of tax. The amount may be measured in many ways, but decided cases established a clear distinction between the subject matter of tax and the standard by which the amount of tax is measured. These two elements are described as the subject of tax and the measure of a tax. The court also held that the measure of tax, though not always essential, but is often a relevant consideration to judge the
You are
nature of tax.
Mr. Bhuya.
Lordship. Yes, Lordship.
Read the judgment properly, this one. This is a very fundamental of taxation law.
Lordship.
What is the measure of tax? What is the subject of tax? Okay?
Lordship. Union of
future,
India versus Bombay
You play
Tire.
in tax matters.
Lordship. Lordship.
Let's come to paragraph 25.
The court also held that the measure of tax, though not always essential, but is often a relevant consideration to judge the nature of levy. The following passage from so-and-so was approved. It may be and is often so that the tax on circumstances and property is levied on the basis of income, which the SEC receives from his profession, trade, calling, or property. Therefore, while determining the nature of a tax, though the standard on which the tax is levied may be relevant consideration, it is not a conclusive consideration. This court recognized greater freedom in adopting measure of tax to be assessed by its own standard and administrative convenience, and other factors may influence the stage at which the levy may be collected, and there may be deviation in contours of measure of tax, but did not contain him to be diverged from the nature of tax by observing as follows. Any standard which maintains a nexus with the essential character of the levy can be regarded as a valid basis for assessing the measure of the levy. With this premises, this court found that while nature of an excise levy is indicated by the fact that it is imposed in respect of manufacture or production of an article, the point at which it is collected is not determined by the point of time when manufacture is completed, but will rest on consideration of administrative convenience, and that generally it is collected when the article leaves the factory for the first time. The question of tax on sale of goods may be examined in the same background. The subject of tax being sale, measure of tax for the purpose of quantification must retain nexus with sale, which is the subject of tax. As noticed above, tax on sale of goods is tax on the vendor in respect of his sales and is substantially a tax on sale price. The vendor or buyer cannot be taxed divorce the subject of tax, that is sale by the vendor or purchaser by the buyer. The four essential ingredients of any transaction of sale of goods includes price of the goods sold. Therefore, in any taxing event of sale, which becomes a subject matter of tax, price component of such sale is an essential part of the taxing event. Therefore, the question does arise whether a particular taxing event of sale could be subjected to tax at the prescribed rate to be measured with such price, which is not the component of the transaction of sale, which has attracted the sales tax. Andhra Sugar case was concerned with the challenge to levy of sales tax under the Andhra Pradesh to so-and-so Act. The tax was levied on the purchase of sugarcane as per the weight of the goods purchased. One of the contention raised before this court challenging its validity was that tax must be levied with reference to the turnover only, and it cannot be levied with reference to the weight of the goods purchased. The contention was rejected by this court saying, where the purchase tax is levied on a dealer, the levy is usually with reference to his turnover, which normally means the aggregate of the amount of purchase price. But the tax need not necessarily be levied on the dealer by reference to its turnover. It may be levied on the occupier of a factory by reference to the weight of the goods purchased by him. However, where tax is to be measured in terms of price or in terms of weight or quantity of goods sold, whether the measure can be different from the contents of taxing event was not the proposition laid. It was observed in so-and-so. It is a superstition cultivated by familiarity to consider that all sales tax must necessarily have nexus with the price of the commodity. Of course, price is the basis and not only usual, but also safe to avoid unequal burdens. Although it is conceivable that a legislature can regard prices which fluctuate frequently as too impractical to tailor the purchase tax, it may even be in rare cases iniquitous to link purchase tax with price, if more sensible basis can be found. It was a case in which weight of commodity was made the basis for levy of tax, The price of goods was approved to be the usual meaning of levy of tax on sale of goods. It does not deviate from the basic principle that a tax of any nature is determined ex hypothesis on occurrence of the taxing event. Its actual computation and collection takes place later on through the machinery provided. However, the determination of chart ex hypothesis instantly on occurrence of the taxing event, which inheres into that measure of tax is integrally connected with occurring of the taxing event and is not postponed to a later date. Thus, primarily the rate of tax relate to measure of tax to come into existence simultaneous with occurrence of taxing event. The machinery provisions relating to its quantification collection can take place later, providing measure to which rate is to be applied is integrally connected with the chart itself. This court considered the omnipotent scope of legislative power of the state legislature while imposing tax on sale of goods in total Balaji. So long as the levy retains the basic character of a tax on sale, legislation can levy it in such mode or in such manner as it thinks appropriate. In this connection, it is relevant for the present purpose to notice that in upholding the validity of additional purchase of tax on goods, when the goods manufactured by the buyer are sold outside the state, tax was related to purchase price, which was part of the transaction of purchase and not payable on price at which he shall be selling his goods. Therefore, it retained its character on tax on purchase. Otherwise, it would have become duty of excise on value of goods determined in terms of price charged by the manufacturer, where such sale was not subject to tax levied by the state legislature. In the court emphasized that tax on sale or purchase must be concurrence of taxi payment of sale transaction. While accepting the price of the sale consideration not necessarily the only criterion which may vary, may form the basis of levy of tax, but it appoint the price as basis not only usual but also safe to avoid uneven burdens. Court also stated that it is common sense that the reliable standard is the price. Although in regard to custom duties, there are still items on which duty is levied on the nature of goods rather than its value in money. The issue which the court was considered was the levy of tax on sale.
Kindly come to this para 49. Now, this forms the most pertinent issue here. The retail price of a formulation.
Formulation needs determination under para 7 of the order. And
Because
the
here, Ms. Haveli, the issue was this. That look here, the MRP is the price at which the retailer is going to sell to the consumer. And there will be, in addition to that, the tax. So therefore, can you impose or calculate the turnover of the sale made by the distributor to the retailer at the price of MRP? That was the issue. So therefore, which is however different from here, this is not the issue out here, but then also the issue there was, can the turnover of a distributor be calculated on the sale made by the distributor to the retailer at MRP? Or is it something less? Because it is after all our business. If he sells him in the retailer, what would he get when he sells it to the consumer? So there has to be some form of consideration for which he will do it. So this answer you find it at paragraph 49. Let's see.
The retail price of a formulation needs determination under para 7 of the order, and the government is empowered by the order to fix the price in accordance with para 7 of the order to be charged by a retailer, where the maximum retail price is fixed as provided under para 7 of the control order. Para 19 provides for price that can be charged from a retailer by a wholesaler. It reads as follows: price of formulation sold to the dealer. Manufacturer, distributor, or wholesaler shall sell a formulation to a retailer unless otherwise permitted under the provision of this order or any order made thereunder at a price equal to the retail price as specified by an order or notified by the government, excluding excise duty if any, minus 16% thereof in case of scheduled drugs. Applying the principle.
So this is the benefit which the retailer gains, minus the excise duty and minus 16% thereof in the case of scheduled drugs. Applying these
principles enunciated above, the inevitable conclusion is that when the wholesaler sells any formulation to a retailer in bulk quantity, taxable event of sale of goods takes place where the wholesaler and retailers are the parties to the contract. The goods in question are the formulations and the consideration is one which is agreed to between the parties to that transaction within the limits permissible by law. By substituting the assumed quantity of goods or a price which is not the subject matter of that contract of completed sale for the purpose of measuring tax, the legislature assumes existence of contract of sale of drugs by legal fiction which has not taken place and which cannot be considered to be a sale in the manner stated in the Sales Act, which alone can be subject of tax under entry so and so 54 of this 2. Substitution of assumed price or the assumed quantity in place of actual price quantity in a completed sales transaction for the purpose of levy of tax on the subject matter of tax results in taking away from its character of sale of goods as envisaged under the Sales Act. Another distinguishing feature to be kept in mind is that the central point of legislature under entry 54 of these 2 of the 7th schedule of the Constitution.
Now, madam, in that perspective,
Yes.
so therefore the answer we get it here. Now, you have no quarrel with the fact that you are also not saying that you have sold to the retailer at MRP. That's not your case. You are okay with the turnover calculated minus the free samples, which were sold to the retailers. So therefore, that price minus MRP minus the price, which has been calculated for your turnover is okay. If that is okay, then in that regard, yes, it has to be, shall be calculated and pay tax on the MRP may not be proper as per the notification. But the revisional reassessment orders as well as the revisional orders are proper for that purpose. Because you have given free, that is another consideration, which is a contract which you have given it for free. That okay, if you take 10 samples, we give 3 samples free or 1 sample free. That is a marketing policy.
Yes.
But if it is not backed by an order, which it is here, and backed by an order that you cannot charge more than this or particularly more than that, then in that case, it has to be taken as a part of your turnover. Only thing is, it may not be as per the MRP, taking into account that the wholesaler is not going to sell it at that price. But you are now okay with that. That aspect you are okay because they didn't charge you at MRP. What do you say, Mr. Bhuya?
Lordship, in paragraph 6 of our affidavit, has been categorically, everything has been laid down as has been fallen for your Lordship.
What does it say?
Lordship. If I may read it, Lordship.
Para 6.
Paragraph 6.
You have put it in such small letters so that this court cannot read it. Is it something like that? Then?
Lordship, it was filed in 2019.
Or is it something like the CGST?
No,
That
no.
department doesn't have the money to pay its lawyers, something like that is happening to you?
No.
Okay. Agi,
If I may read, Lordship.
let's
Uh,
see paragraph 6.
That as regards to the statements made in paragraph numbers 12 to 21 of the writ petition, the opponent begs to state that the dealer had provided a large quantity of medicine free of cost to the retailer in the form of quantity discount as a common practice of business whose value runs into crores of rupees in a financial year. These are not free samples as stated by the petitioner. The deponent further submits that before completing the proceedings in the matter of turnover escaping the assessment, the dealer was given several opportunities with reasonable time to adduce his points. But the dealer did not even bother to produce books of accounts, not to speak about adducing his case. Under such circumstances, waiting for further time, as the first notice was issued on so and so, the assessing officer had no other alternative but to conclude the proceedings based on the value shown in his audited account on so and so. It is to be noted herein that the relevant year to which the proceeding is related, the medicine was entered in Schedule 4 of the VAT Act of 2003, taxable on MRP and governed by Section 10, where it had been clearly explained its explanation
Let's
3.
see the VAT Act.
Lord-
Schedule 4.
Schedule 4, Lordship. Explanation 3.
Serial?
Uh, Not,
Serial number? Medicine. Medicine. Drugs and medicine, including vaccines and so. The expression drugs shall not only include demand. The explanation has been inserted by notification dated so and so. The words including vaccines so and so. Now 6%. Madam, how do you take care of entry 21 of Schedule 4?
Drugs and medicines on MRP basis. Lordship, this was, Lordship, this was substituted and brought into force. Lordship. MRP basis. Drugs and medicine on MRP basis, 6%.
No, 6%, I'm not on that. But this is an entry in the schedule. It may be wrong. But without a challenge, forget about a notification, without a challenge to this entry, can you succeed? Besides the point, which obviously you may have a case on that as regards a challenge to this notification, because when it becomes a part of it, this entry is a part of the schedule to the act. So it has to be challenged accordingly. That is another thing. But what has happened is you are challenging a notification here. It may be wrong, but that would not impact taking into account that you need to challenge this entry 21. Because doesn't it form a part of the act now? Let us see how 110 is worded. Power to remove difficulties. If any difficulty arises to give effect, isn't it done under 110? 110 what? Section?
Section 110 of the power to remove difficulties. No.
By notification in the official make such provision not inconsistent with the act as it appears to be expedient. Now, this is a notification under 110. It seems to be more clarificatory, but the fact remains out here that in a Schedule 4, it says on MRP.
In the record.
Huh?
This entry has come into.
The entry is there. Wasn't it there? Well, your period is from when?
My 2007, 8, 9, 9, 10.
This appears to be, let us see, 6th schedule. You see the down below, amendment A. The explanation has been inserted by notification dated so and so 2005. The words including vaccines, disposable so and so have been inserted by 2005. So earlier, drugs and medicines, including vaccines so and so, were inserted later. But earlier it was only drugs and medicine. So it was then also on maximum retail price.
The record is written on MRP basis.
No. In the bracket, on maximum retail price was already there. What was added by this explanation, the explanation which was added in 2005, that is prior to your period. The expression drugs and medicines shall not include products capable of being used as so and so. The explanation has been inserted. The words B, the word so and so has been inserted by 2005. So this comes prior to that. But be that as it may, this is a part of the act.
Even if Lordship, even if we considered it as a part of the act, the same is Lordship wrong as been said.
No doubt it is wrong. No doubt it is wrong, but you have to challenge that. Without challenging this thing, which is there on MRP, but it is not here that you are aggrieved by the MRP being put. You say that it should be 0.
I say that it should be 0 because
0.
it's
So you say it is free sample. But your free sample is on the basis of your contractual agreement. That if you take 10, we give 2, 3, 4 free. Now, whether that is a discount being provided can be taken into consideration. But I think, madam, there are few other judgments on this point.
Yes, sir.
On where what happens when discounts are provided.
Yes.
Let us see further what he is saying on paragraph number 6.
Lordship,
Noted here that the relevant year of for which the proceeding is related, the medicine was entered in so and so and governed by section 10, where it was clearly explained the explanation in explanation 3 that a tax on sale of goods specified shall be levied and collected on MRP in so and respect to so and has been made on the basis of there. Where the maximum, now let us see explanation to section 3, section 10. Which one? Mr. Bhuya, what, which explanation you are referring to?
sections, section
Governed by
10,
section wherein it is clearly mentioned in explanation 3.
Lordship,
Where is the explanation 3? When did you, oh yeah.
Lordship.
Here you go. A tax on sale of goods in the fourth schedule shall be levied and collected in maximum retail price. Now, madam, how do you take care of this again? Without a challenge. For that purpose, where the maximum retail price printed on the package of the air is leviable exclusive of taxes, local taxes, etc., then the base of the levy of tax shall be such maximum tax, where the maximum retail price printed on the purchase of the goods is inclusive of all taxes, then the base price shall be such maximum year as reduced by the tax element included therein, which shall be calculated by applying the tax fraction. But this explanation remains.
Explanation will be.
Then,
So, Lordship, kindly see their own affidavit, Lordship.
that is what I am saying. Yes.
See the paragraph 4 which you have written, Lordship, may kindly see.
Going through the returns submitted, audited accounts of the year, it has transferred the petitioner paid taxes by multiplying the aggregate of the MRP as declared in his return. He had not deducted the tax fraction from the MRP. This implied that he threw open to the market his product with clear instruction that ultimately the customer has to bear the extra tax in addition to the MRP printed on the body of the package, and those goods which were given free as quantity, discount, or whatever name it may be, ultimately has been sold to the public along with other goods. But in a question arises as to whether one can give his retailer free quantity along with the goods sold for promoting his business, but it is a fraud on the consumer and the society to get paid extra taxes over and so the free samples which is being given is in the form of a discount or a price consideration.
Lordship, to a supplier is free of cost to the as promotional method.
So why do you promote? You say that, okay, take my thing, this one, that if you take one, I'll give another one free. That's the promotion.
That's the thing. Yes, Lordship.
But that means when you are giving somebody, a seller, you are giving it to the consumer, it's okay. But if you are giving it to a retailer, it means that you are giving the retailer at 50% the price is the discount.
Yes.
Nothing to us.
This aspect I did not go into.
This is how can I look into that, taking into account that, you see, unless you challenge, because the Rajasthan judgment will only come in aid to challenge explanation 3. You cannot have it on in respect to medicines because they are already scheduled. But the schedule is at page 49, paragraph 49, which I have referred to. Paragraph 49 says, if you have to therefore develop your arguments on that basis, that how it is happens. But there, the question is different, whether it is on the MRP. You are not on that. You say that, okay, this is the thing, I have a promotional thing that if you take one, I'll give another one free.
Fact, Lordship, when we consider that the aspect of the concept of sale price, Lordship, whenever how the tax is to be levied, Lordship, if it is given without a consideration is the main thing, Lordship. Without consideration, if it is given, Lordship, no tax can be levied, Lordship. Even the Rajasthan High Court, Lordship, the division bench of the Rajasthan High Court also has held, Lordship, in this case.
No. Without consideration, if you give free of cost, which you are not required to give free of cost. I am required to give free of cost. You see, just for example, that is why I'm saying, physician sample not for sale. It normally goes to the doctor. This is being given as a promotional out here, which you are required to do for your purpose of, because the doctors are going to do it. Are you saying that the retailers are advertising? No, the retailers are being given the thing that, okay, why, instead of giving you any other discount of 25%, we give you one free out in 4. That is it.
They are saying that, Lordship, we have given it as a promotional measure, Lordship. Now,
That
how it has been
is
given
that
as a promotional
in madam, rose is a rose in whatever color it is. It's
And since it is given as free samples, they have accepted the fact that it is given as promotional measure.
yes, it is free sample.
Accept-
There is no quarrel. It is not a quarrel that you have given it free. It's not free. It is part of your consideration that you are giving 25% discount when you are giving 4, 1 is free or 20%.
This, Lordship, I have to take instruction from my client that how it has been given as a promotional.
What is
measure.
there to take instruction?
Because Lordship, this, Lordship, aspect of the matter.
Your case
Lordship,
is finished.
that whether how the Lordship, whether it was given as
Any judgments on discounts being given, forget about this.
Yes,
Rajasthan would not help you. And more particularly when you have not challenged. Rajasthan would help you if you are challenging explanation 3 to the act
yes, sir.
and saying that you cannot impose us.
Yes, sir.
When I was at the bar at that point of time, I had a lot of matters pertaining to this medical matter where they were having a lot of difficulties when they were selling it. Because that was given as inclusive of taxes at that point of time. Then when it was inclusive of taxes, then what was happening that they used to, these people used to then, the taxable turnover used to be taken minus the tax. This used to be the taxable turnover because this was under the 1993 Act. There also it was at the first point of sale. But a problem arose is with these dealers. Certain amount was remain always unaccounted for. And there was no challenge all along to that provision that there is, in view of the control orders, there is a requirement of having a particular margin for the retailer. That has never been challenged anywhere. This is the case where it was being challenged out here in Rajasthan. And that is how it went. But as of now, we cannot look into that for the purpose without a challenge to explanation 3. Anything else?
I'll come out with the.
What is there?
Judgment.
I'll forget.
Lordship, because in the
Good case now for dictation. There are judgments for when discounts are given, then what happens? Any judgments
Yes, but this particular judgment also is dealing with,
from?
this is also from Rajasthan High Court. This is different what is given.
Hey, go ahead, go ahead. Supreme Court, on the question of discount, how if there is a discount being given?
Yes.
Because you see, the thing is, you are a distributor.
Yes.
The chain is like this. The company has its CNF. The CNF as well as the company, they are one.
Yeah.
It's like an agent. So the moment the company says that, okay, take this amount, the CNF transports it. Now here, now unless the company says, company must have given you instruction and 10 you give 2 free. That means that amount of money is also being taken care of by the company because the distributor doesn't have to do it.
Yes.
So the company is already taking care of that, the benefit of you. And therefore, wouldn't it be double enrichment for you? Because here the company is not giving that benefit. It's already bearing the burden for the 2 out of 10 and saying, okay, you give 2. And when he takes 2, he gives the benefit. Now the problem is, which you have got the free of cost. You are doing the business on behalf of the company.
I have to, Lordship, one thing I'll, Lordship, on the next date, I will come with the instruction on regarding how the promotion, because when the case was given to me, Lordship, if I remember well, it was.
But the fact, madam, the thing is, your case as it stands, there's nothing wrong with the orders passed by them. Why should I then reopen it?
It's something which has been given, Lordship, my endeavor was to, Lordship, show to your Lordship, first thing was that since something has been given free of cost, no tax.
Madam, you have to see, madam, you have to also appreciate, I'm not sitting as an appellate authority. The fact that you were issued 2 times notice is a fact which is stated by them,
Yes.
not denied by you to the effect. You say, okay, the principles of natural justice and all this thing. That is one. Second, he has done so without looking into anything. He said that we have been asking him, he has not, so therefore we take care of this audit objection and then issue the order of reassessment. That is being done. You file a revision. Revisional authority looks into it. I am exercising the powers of judicial review to see as to whether the right order is right or wrong. Not right or wrong, whether it is permissible for this court to enter into this fray.
Lordship, with my humble submission, Lordship, since in this case, the basic moot question which comes before your Lordship is whether as a promotional measure or as a discount. Lordship, if it may be taken that it was sent as a discount also. Lordship, even if it is sent as a discount, on the discounted portion, can they collect the tax?
Why not? You are giving it. Who has asked you to give it? You see, the law makes it very clear that the moment there is a transaction, here you give a 25% discount by saying that, okay, 3 against 1, against 3, I give 1 free. So this is a 25% discount, which you ought to have taken it there.
Yes, sir.
As a turnover.
Yes.
But you say that, okay, against this, I'm giving you 25% discount. Instead of giving him the money or having the discount, then take the free sample. It is not actually a free sample in sense. They may have said that it's free sample. You have also said that this is in the parlance known as a free sample. But it is an extra sample which is being given. 1 shirt, bihu,
Buy one get.
another shirt free. Or if you just, for example, if you buy 2 shirts, 1 shirt is free,
Not sure.
which means 33% discount. But then whether that person concerned, would he say that, okay, I'm not going to pay on this 22%. Anyways, as you are, I will give you another chance. But the problem remains is once you have looked into this aspect, then it becomes very difficult. Again, I may forget. What?
Make it parted and fix the matter.
Partner? Partner is okay. I've already heard. Anyways, let me jot it down in the order.
Gotcha.
Heard Miss N. Haveli, the learned counsel appearing on behalf of the petitioner. Mr. M.K. Bhuya.
M. Bhuyan, Lordship.
M. Bhuya appears on behalf of. You read that judgment, huh?
Lordship,
That
Lordship.
judgment, not this one. Those judgments.
You-
Then you will understand how the text works.
How did they? Lordship. Lordship, Lordship.
Who appears on behalf of the respondent department. These 3 writ petitions have been filed against the common revisional order passed by the Joint Commissioner of Taxes for the assessment years 2007, that's 2008, 2008, that's 2009, and 2009, that's 2010, under the Assam Value Added Tax Act 2003. Ms. N. Havilia, the learned counsel appearing on behalf of the petitioner, had submitted that the respondent authorities, department, had passed reassessment orders.
How dare
It's not required, no? Self-assessment is required.
there are provisions?
Madam, when there is a self-assessment, isn't it the provision out there you need to do self-assessment? There are 3 types of assessment: self-assessment, audit assessment, scrutiny assessment.
Yes.
So this is the self-assessment. I've carried out I have passed an order in that judgment also that can be done. Anyways, passed the order of reassessment, orders of reassessment, thereby imposing tax on the free samples which the petitioner, it's a company. We petitioner firm or company?
Company.
The petitioner company as distributor, as wholesale distributor, have provided to the retailers. The learned counsel submitted that in respect to free samples which have been provided to the retailers by the wholesale distributor, as there is no sale price on such free samples, the question of imposition of a tax on such free sample is not permissible. The learned counsel further submitted that this aspect was brought to the notice of the revisional authority by filing 3 revision applications. However, the same was rejected by a common order passed on 10/5/2018, which is the subject matter of the 3 writ petitions. The learned counsel referred to the judgment of the Supreme Court in the case of State of Rajasthan and another versus the Rajasthan Chemist Association reported in 2006, 6 SSC 773. And as per the submissions of the Learned Council, the said judgment holds the failed, the said judgment would show that the impugned order as well as the impugned notification, which forms the basis of the impugned order, cannot be sustained in law. This court have duly perused the judgment of the Supreme Court in the case of Rajasthan Chemist Association, Supra, and the issue involved therein is as to whether the taxable turnover of a distributor, wholesale distributor, is to be calculated on the basis of the maximum retail price or on the basis of the price at which the wholesale distributor have sold the medicines to the retailer. First, in the prima facie opinion of this court, the issue involved in the instant case, however, is different. And the same judgment in the case of Rajasthan Chemist Association, Supra, would not come in aid of the petitioner unless and until the explanation 3 to section 10 of the Assam Value Added Tax 2003 is not challenged. First, be it as it may, Ms. So-and-so, appearing on behalf of the petitioner, submitted that taking into account that the instant writ petition is already 8 years old, 8 years old, she would like to obtain instructions from a client as to the mechanism in which the petitioner as a wholesaler sold the goods, the medicines, drugs and medicines to the retailers, in respect to which free samples were being were distributed to the retailers. List the matter again on 24 to 2026 at 2 p.m. for final disposal. Showing it as part of it.
Much obliged, Mr.
I think, madam, you may have on this aspect consideration, this discount. Somehow read it. That is why I gave you. Otherwise, I would have finished it.
Try my best.
I will look at it.
Much obliged, Mr.
Also, on the last occasion, we directed to take the status report, present status of the case. I have received the
What is the case?
Lots of the brief facts of the case is initially the petitioner here, he had filed a complaint in RERA because the builder refused to refund the money or give the possession of the flat. The order of RERA was passed in the favor of the complainant, whereby the promoters were directed to refund 45 lakh rupees along with the interest, totaling up to 72 lakh rupees. They did not they did not refund the money in stipulated time period of 45 days. Thereafter, an execution petition was filed. In that execution petition, the DC office was directed to recover the money as arrears of land revenue. And that proceeding has been going on since 2022, whereby they should follow the provisions of Bengal Recovery Act. They are not following the procedure established by law. So we had filed a writ petition asking them to recover the money as established by law and in an expedite manner.
What is the procedure established by law?
So as per the Bengal Recovery Act, they should have issued after the recovery certificate was issued. They should have issued a notice and given 30 days time period for the promoters to refund the money. If they fail to refund it within the 30 days period, then they should start attaching the properties. They did not attach any property, and they were in fact asking us to submit a list of properties that the promoter have. We have even submitted a list of properties that the promoter have, but they failed to attach the property. Now, in the recent development of the case in last year, 2025, now they have started to release individual directors from the case. They have started to release the individual directors of the promoter company, saying that they have resigned from the company. Lordship will find that order in the IA. An IA has been filed by one of the directors asking them to implead in our matter and to release them from the liability. In fact, Lordship, the IA that one of the directors has filed, namely Dulu Ahmed, he was the signatory in the deed of agreement signed by the complainant, petitioner hearing. Already 4 years has gone by. The recovery proceeding is not taking place as per law. They are releasing every directors one by one. And if all the directors are released, then the decree will only be on papers. And also the complainant is missing out on the interest for last 4 years since the matter is pending before the Bakijai office.
Let us see the order of RERA.
Lordship will find page number 24 of the writ petition.
Which writ petition?
5817, item number 6. The effective portion is on page number 41. Page number 40. Has your lordship got it?
Page 24. What is the direction?
There were 3 directors.
An agreement dated so and so executed by so and so has been terminated. Who is the promoter?
Lordship will find it in page number 33, one of the promoters, Babul Chaudhary.
Who is the promoter?
In order sheet, Lordship will find it in the order sheet.
Where is it?
Order sheet, order dated 4/2/2025. There were three directors, Dulu Ahmed, Babu.
Who is the
Chaudhary.
promoter? My question is simple. Who is the promoter?
Promoter are three individuals. One is Dulu Ahmed, one is Babu.
Where is it mentioned?
Page
That
number
order?
8. In the order sheet of Bakijai proceedings,
In the order of the RERA,
in the order of RERA, only the name of one of the promoters is mentioned.
where
Lordship will find it in page number 33 of the writ petition. Roman number 3. The complainant states the fresh power of attorney, a deed of agreement was executed between the landlords and so, whereas the agreement so was executed between the complainant and respondent was signed by the director Babu Chaudhary on behalf of Messrs. Me Infrastructure.
no, I'm not there. Here the direction is to the promoter. Now, who is the promoter?
Here against the whole company, that is Me Infrastructure.
Therefore, it is the company.
It
is
is
the
company.
promoter.
Yes.
Now, if it is the company, let us see the RERA Act, which may say who is the promoter.
Lordship will find it in section number, section 2 ZK.
Person who constructs or causes to be constructed an independent building or building consisting. Person who develops land. So therefore, it is being done by the company.
It is done by the company.
So the company is the promoter.
Yes.
So a company is limited by shares.
Yes. Lordship
So
also.
therefore, the question is, what are the assets of the company?
Also, Lordship, one of the aspects is they have tendered one of the resignation. There were three directors initially in the company.
But where is the company? Does the company have any assets?
That is on the Bakijai office to evaluate from the circle office.
What
We
is
do
that?
not have the list of the assets of the company.
Which is the company?
It is Me Infrastructure Private Limited.
Huh? Me Infrastructure Private Limited.
Yes.
Okay.
And as per the Companies Act also, Lordship, even after one of the directors has resigned from the company, if any fraudulent act was done prior to resignation, the directors would still be liable. So one of the IA which is filed by the director, he's saying that he has tendered his
Madam, why you are into this IA? We'll get into the IA later on.
and even in
The
the order.
question is Me Infrastructure Private Limited.
Yes, Lord.
Now, what is the status of the company now?
Lordship, we are unaware about the status of the
Did
company.
you find it?
However, the representative.
Did you find it in the company's Ministry of Company Affairs website?
Lordship, we had actually gone through the website. It is showing that it's a doormat company now because they have failed to furnish their reports in 3 years. So ROC has struck down their name from the registrar of companies. As per our research. However, their representative, the company's representative is appearing before Bakijai office and they have not taken any such plea that the company's name is struck off or it is a doormat company or it is not functioning. They are.
So the question is, the question will arise out of liquidation then,
Yes.
don't you think?
If they take a plea that the company is no more operating, but they are not taking that plea anywhere.
Not necessary. Now you have an order by which there is a direction for you to return 45 lakhs to the complainant along with applicable interest.
Lordship, I am representing the complainant. I am representing the complainant, not the promoter.
Understood, madam. I have understood that you were the complainant, you entered into an agreement with Mimi Enterprise or whatever may be. And this Mimi Enterprise have not given you the particular plot of land or flat in that regard. Therefore, you moved the RERA authority. The RERA authority said that this is not done properly. So therefore, directed making payment of you by the promoter an amount of rupees 45 lakhs along with applicable interest. Now, this was passed in 2002. Then what happened?
22.
Then what happened? 43 is what?
Thereafter, lordship proceedings in Bakijai office is being conducted even now, whereby one of the directors has approached the Bakijai office saying that take 10 lakh rupees check and we'll pay it in installment
Who?
within 6 months. One of the directors, one of the representative of the promoter company. So thereafter, we had refused because we don't want to take the money in installment. And even after that 6 months period has lapsed long back, they have failed to give us the money back. And then thereafter, in the Bakijai proceeding, arrest memos were issued in the name of the director since they have failed. That is also provision under the Bengal Recovery Act. Then the Bakijai office took back the arrest memos and said that against one of the directors, his personal assets were evaluated and valuation was taken. Now the auction proceedings is pending.
Which are the properties?
Lordship will find it in the order sheet of the Bakijai proceeding. 9/9/2025.
Yes, Mr. Alam, for whom are you appearing?
And lordship, if I may take your lordship to one more order of the Bakijai proceeding.
Want to say anything? May I please, Lordship? Lordship, I am repeating here Babul Chaudhary, my lord, in IA, my lord. Babul Chaudhary, my lord, had resigned from the directorship long back prior to institution of RERA proceeding, prior to institution of proceeding before the RERA, my lord. Prior to that, my lord, Babul Chaudhary has resigned from the directorship, my lord. This is well known to them also because thereafter, since in my individual capacity, I went on carrying business with the complainant, my lord. I went on carrying business of real estate development by purchasing materials from the complainant company. This is well known to the complainant company, my lord. Thereafter, my lord, they proceeded the RERA against the company without implementing the directors before the RERA, my lord. RERA issued the order for refund of money. Then, my lord, money was not paid by the company. Then recovery certificate was issued to the Bakijai officer. For the first time, my lord, Bakijai officer, without taking any action against the company, had issued your lordship arrest warrant against Babul Chaudhary. That against that arrest warrant, my lord, immediately, my lord, your lordship cannot see annexure 1 of IA. Annexure 1. Page 18, my lord.
Yes.
Immediately, I have filed an application under Section 9 of the Bengal Public Demand Recovery Act 1913 that I am not liable to satisfy the certificate under the circumstances stated herein. My lord, Bengal Public Demand Recovery Act 1913, Section 9 says, my lord.
Where is your resignation? Accepted by the.
Accepted by the board. Accepted by the board, my lord.
Accepted by the Ministry of Company Affairs. Where?
My lord, that board resolution is required to be forwarded by the directors of the board, my lord.
Where is your resignation accepted by the Ministry of Corporate Affairs?
No, my lord, whether they have forwarded it to or not, my lord, is not known to me, my lord. Because board has accepted my resolution, resignation. This is one aspect, my lord. Then, my lord.
Mr. Alam, you also know, I also know. Merely submitting it, but if it is not uploaded in the website, would have no value.
All right, my lord. If it is not uploaded, my lord, then, my lord, in the garb of relation of money against the company, Bakijai officer is not having an authority to attach my individual property, my lord.
So
What Bakijai?
therefore, you give good advice to you along with your other three friends which you had and make the payment to the petitioner.
And in the meantime, your lordship, I cannot see page 107 of my IA, page 107. Is it within the jurisdiction of Bakijai officer, my lord? Page 107.
Yes.
This is order dated 3/3/25.
Hmm.
He all along he had contested before the RERA, taken part in the proceeding. And Bakijai officer has exempted him.
We challenge this order, madam.
Not challenge, my lord.
Lordship,
One
this
zero
was
seven.
submitted now in 2025 March. And my petition was filed in.
Now, who
2022
appeared?
April, wherein-
Why this order was passed, Mr. Talukdar? Why this order was passed? Wherein an application has been received from so-and-so that he had already resigned from so-and-so on Iman. And accordingly, the company accepted his resignation on Iman, which have been further sent to ROC through email. Whereas an application received from so-and-so informing so-and-so is not related to, who is Ganesh Bora?
He is the
Other
director.
director of company.
And he said that he will be responsible.
My lord, he has given undertaking. No action has been initiated against Ganesh Bora till now, my lord, by Bakijai officer.
What
It is
actions the Bakijai officer is taking against Bora?
nothing, my lord, on record.
Is the proceedings before the Bakijai officer stayed? No.
No, Lordship.
Okay. But I don't understand this order of 107. What is wrong with this Bakijai officer? After all order has been passed in the year 2022, the Bakijai officer just slightly removes him.
Removed him from the.
And how is he doing all these things?
Now, my lord, Bakijai officer has been proceeding in respect of property, my lord, your lordship, I cannot see in Annexure 7. In Annexure 7, my lord. Bakijai officer has been proceeding against my individual property, my lord, without taking any steps against the company and its assets. Although certificate is against the company. Page 62, most late. যেটো আপনার তার রিপোর্ট আছে অ্যাটাচ করা আছে রেজুলেশন দেওয়া আছে
Madam, why will you not challenge 107?
Lordship, this is in the year 2025 March, this order was issued and we were not called in the Bakijai office that such kind of resignation has been submitted by the.
Because if you don't
the
challenge
director.
this order, we have no other option but to let him out.
Lordship, we have challenged the whole proceeding in our writ petition. This is the subsequent proceeding.
You cannot challenge the proceedings. If you are challenging the whole proceeding, we have to set aside the whole proceeding, which will not be in your interest. Unless you challenge this order 3343, you need to challenge this order.
লর্ডশিপ I cannot see page number 100 of my lord. After release of Dulu Ahmed, my lord, they have approached Bagijai officer, shown my property, and got the order dated 9925, my lord. Page 100 of my IA, my lord.
What is that? Received from Pradeep Gupta regarding providing.
9920.
details,
A
report
letter
of
received from
process
Pradeep
of
Gupta regarding property of detailed report of me infrastructure director Babul Chaudhary in Dona Planet, shop number so and so. These are, my lord, not the property of the company. These are my individual property, my lord. Pursuant to this information, my lord, they have Bagija officer had issued a letter to the executive engineer for valuation. So all along they are having knowledge.
No, madam, tell me another thing. If there is an award passed against the order passed against the company, how will the officers of the company be held?
Lordship, under the definition of promoter, all the directors are jointly and severely liable to repay the money.
Where? A person who constructs or causes to be constructed any independent of so-and-so apartment or demand thereof for the purpose of selling and includes his assignee, a person who develops
Only
into a
against company.
project whether
Only against
or not the person also
no.
constructs structures for selling of a man of the man whether he is so. Any development authority or any other public body in respect of so-and-so. Any other person who acts himself as a builder, colonizer, so-and-so, so-and-so. Any other name or claim that the man or the power of attorney. Any building for the purpose of the Where do you bring in, how do you say that the directors are involved?
Lordship,
That's how the data is, but yes, 99. Page 99. Page 99. Proprietor.
Yeah, 69. 69 is offenses where an offense under this act has been committed by a company. Every person who at that time the offense was committed was in charge of, was responsible to the conduct of the man shall be guilty of the offense, shall be proceeded against and punished. This penalty for failure to comply with the affiliate tribunal's orders. Registration penalty for penalty.
Okay.
Also, there is a High Court, Bombay High Court judgment wherein the
Madam, kindly see section 38,
1P.
38. The authority shall have the power to impose penalty or interest in regard to any contravention of the obligation cast upon the promoters, the allottees, and the real estate agents under this act, or the rules and the regulations made thereunder shall be guided by the principles of natural justice. This is 38(1). Okay. Now kindly come to section 59. So penalties can be imposed by the authority, RERA. These are offences, penalties, and adjudication. Now kindly see 63. If any promoter who fails to comply with or contravenes any of the orders or directions of the authority, he shall be liable to a penalty for every day during which such default continues, which may cumulatively extend to 5% of the estimated cost of the real estate project as determined by the authority. Kindly come to 69. When offense under this act has been committed by a company, every person who at that time the offense was committed was in charge of or was responsible to the company for the conduct of the business of the company, as well as the company, shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. Provided that nothing shall render any person liable to any person if he proves that the offense was committed without his knowledge, or that he has exercised all due diligence to prevent the commission of such offense. Now tell me, how would this order be sent to Bakizai?
Under section 40. The Act.
If a promoter or an LOT or an agent fails to make the payment by an adjudicating or the regulatory authority, or the case may be under this act, and the rules made shall be recoverable from such promoter or LOT in the manner that may be as areas of land revenue. If any adjudicating officer of the Iman as the case may be issued any order or direct any person to do any act or refrain from doing so, which is empowered to do so under this act of the rules of regulation. Case of failure by any person to comply with such order or direction, the same shall be imposed. Okay. So this is 41. So therefore it goes to the Bakizai.
Yes.
Now, madam, the main problem is you have to first challenge the 3(3), page 107. You file a fresh petition and tag it along with this. Then only we can proceed. That is the only way out. Take the help of 69. And I think you can very well approach the RERA also, the authority.
We did approach RERA. We did say that since 3-4 years now the matter is pending. So what Bakijai office is doing, they are submitting letters to RERA saying that it is a sub judice matter. However, we have said that there is no stay in the proceeding. It is a sub judice matter before Honorable High Court, they are saying. So they are not proceeding.
No. We will make it clear. Let the Bakijai proceed. That is one. Secondly, you approach RERA for initiation of penalty.
Approach, however, Lordship, for 2 years they did not take up our case. They refused to file a case saying that your file is already in Bakijai office. So under
We'll
provision
make
of
it clear.
62. Now they have 2 months back they have taken cognizance in the matter.
And taken it under this
Yes,
59.
this provision under the penalty
60C,
provision.
and read with 69 they
Yes.
can because they were there. But you need to challenge this.
Lordship.
Chalo.
If Lordship, we may file an IA in this matter regarding this order, challenging this order.
No, no IA business. It has to be by way of a writ. And why the other writ petition?
Lordship, there were two cases. One was against Me Infrastructure and the other was against AR International. AR International was a sole proprietorship where the sole proprietor is absconding since the initiation of the proceeding before the
He has
Baki judge.
some property.
And since 4 years, they are just saying that he's absconding, no party, no evaluation of the
The separate orders likhibo, huh? Heard your name?
P. Gupta.
P. Gupta, the learned counsel appearing on behalf of the petitioner. Mr. B. J. Talukdar, the learned senior counsel, assisted by Mr. P. K. Medi, appears on behalf of the certificate officer. And Miss N. Bodler appears on behalf of the Revenue Department of the Government of Assam. And Mr. N. Alam, who appears on behalf of one of the directors, one of the alleged directors of the company in the name and style of Me International. A line 2?
Me Infrastructure Private
Me
Limited.
Infrastructure Private. This is only in 5817, okay? 5823, N. Alam is not there.
No, in other case, I am not there.
Sorry.
I am only in 5817, my lord.
The petitioner herein has approached this court in view of the delay in the implementation of the order dated 19/2/2022 passed by the Real Estate Regulatory Authority of Assam by the Certificate Officer, Kamrup Metropolitan District. Full. The petitioner therefore seeks appropriate writ direction and order upon the said officer so that the amount can be realized from the. You have not made Mimi a party?
We have filed an IA whereby B Infrastructure and RERA was also made a party to this writ petition. It was allowed. And accordingly, we have amended the cost title as well.
Respondent number 6. লিখিলে রাখছেন তো?
না, দুটো available.
Respondent number 6.
At a 4 or 5.
Today, when the matter is being taken up, Mr. B.J. Talukdar Senior Counsel has submitted that the property of one of the directors of Me Infrastructure of the respondent number 6 have been identified and in Donap Planet, in the building, in the name and style of the Donap Planet, and the exact valuation, the valuation can only be ascertained by the circle officer.
The zonal valuation. Now, there is the building, valuation of the building was done. The zonal valuation of land.
Wherein it is mentioned that it's submitted that the building, value of the building belonging to one Babul Chaudhary, who was the director of respondent number 6, have been identified and have been assessed. And as regards the zonal building of the proportion as well as and the value of the proportionate share of Sri Babul Chaudhary is yet to be ascertained by the circle officer. Gauhati Revenue Circle. Gauhati. Pusto. Mr. N. Alam, who appears on behalf of the said Sri Babul Chaudhary, submits that he had already resigned from the respondent number 6 company even prior to the initiation of the RERA proceedings.
Prior to the passing of order.
However, no document could be placed that such acceptance, such order, that his resignation as one of the directors was accepted and uploaded in the Register of Companies website. Mr. N. Alam further submitted that the certificate officer have been pursuing with the Bakijai proceedings not in a manner permissible in law, and in that regard have referred to an order dated 4/3/2025.
3/3/2025, my lord.
He signed it on 4, I say 3.
Date of order is 3/3, my lord.
Let me see when he signed.
One sign he has signed on 4/3/2025.
4/3/2025, wherein one of the other directors who resigned after the order being passed by the RERA authority was let out, whereas Sri Babul Chaudhary
Lordship, kind of CP.
have not, whereas his client's application have not been taken into consideration to the effect that his client, Sri Babul Chaudhary, had nothing to do with the respondent number 6 at the time when the RERA proceedings were even initiated.
Initiated, my lord. Pursuant to page 39, Lord.
It's okay.
This is acceptance of my resignation by the Board of
Pusto.
Directors.
Ms. So-and-so, appearing on behalf of the petitioner, submitted that she was not aware of this order dated 4/3/2025, and the petitioner would be challenging the said order. Pusto. Taking into account the above, list this matter again on 12th of March 2026, 13th of March 2026. Pusto. This court further takes note of that in the meantime, the petitioner herein have already approached the RERA authority for initiation of proceedings, penalty proceedings under section 63 of the Real Estate Regulation and Development Act 2016. Pusto. It is observed that the pendency of the instant writ petition as well as the Bakijai proceedings shall not impede in the progress of such proceedings which are pending before the RERA authorities. It is also being submitted that the Bakija proceedings have recently been again activated, put into motion, which was otherwise not proceeded with in view of the pendency of the instant proceedings. It is made clear that the instant proceedings is for the purpose of giving effect to the order dated, is for the purpose of inaction on the part of the certificate officer in proceeding in the Bakijai proceedings. Under such circumstances, this court observes that the present proceedings cannot be construed as a proceedings which would affect or impede upon the certificate officer not to proceed with the Bakijai proceedings. Full stop. This court further takes note of that an application has been filed by Sri Babul Chaudhary for the purpose of exoneration of him in the Bakijai proceedings, isn't it?
This IA has been filed for his impleadment in this petition, my lord.
For impleadment,
Impleadment in
not
this-
exoneration.
Not exoneration from this, my lord. Thereafter, my lord, I will place my say, my lord.
ঠিক ঠিক এটি said it হয়ে গেল two orders. And in that other case,
Lordship, the parties absconding since 4 years now, none of his properties has been evaluated or attached.
My lord, may I?
first, এখানে দেখো, wait, his IA এখানে দেখো. This is an application filed by the applicant, Sri Babul Chaudhary, seeking impleadment in the accompanying writ proceedings. Taking into account that any order so passed in the instant proceedings would impact upon him. Full stop. It is the opinion of this court that the said applicant is a necessary party to the instant proceedings. Accordingly, the instant application stands allowed. And the applicant herein is impleaded as the respondent number 7 to the accompanying writ petition. The counsel for the petitioner is directed to file a fresh memo of parties before the registry of this court. And the registry shall, on the basis of the present order as well as the fresh memo of parties, make necessary correction in the cause title and update the same in the CIS. I stands disposed. He is today Mr. N. Alam, who appears for he Babul Chaudhary respond number 7 বুলি কইল. Babul Chaudhary. Mr. N. Alam, the learned counsel, further submits that he would also file an affidavit in opposition in the instant proceedings. When did I fix the date? 13th, na? 13th. Full stop. Liberty given to file affidavit in opposition on or before 6th of March.
March.
Full stop. Liberty, the petitioner would be at further liberty to file reply on or before 12th of March. It took case. I dispose and so and so.
My lord, Bakija proceed, officer may proceed against the company, my lord, not against me, my lord.
Not now. You only said I was about to pass the order. You
But my
said that that is
my
only
lord-
for
my
implement.
lord,
No, Mr.
already order has been passed, my lord, in the
Very
petition, my lord.
good.
Now they will put my property in auction, my lord.
Fantastic.
So I shall
So
not be happy.
therefore, in the meantime, you try to impress upon your fellow.
No, my lord,
persons.
I don't have any collision with him, my lord. They
Mr.
are having,
Mr.
petitioner,
Alam, I also know, you also know. You
petitioner is
have-
having collision, my lord.
Anyways, division bench may help you. Econdi. 5820 of 2020.
Much obliged.
23. Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. B.J. Talukdar appears on behalf of the certificate officer, Kamrup Metropolitan District, so-and-so, so-and-so. N alam nalage, huh? Okay. The present petition has been filed by the petitioner, being aggrieved by the inaction on the part of the certificate officer in taking action in pursuance to in taking action, have you filed an, in taking action against the respondent number 6 in pursuance to the order dated 1/6/2022 passed by the Real Estate Regulatory Authority. Pursuant to the order it is noticed that in pursuance to the order passed by this court on 9/2/2026, a status report have been placed before this court to the effect that the respondent authorities have not been in a position to effect to obtain information as regards any land belonging to the respondent number 6. On the ground that the circle officer of the concerned circle have not provided such information. Mr. P.K. Medi, the learned counsel who assists Mr. B.J. Talukdar, the learned senior counsel, shall inform the circle officer of the Gauhati Revenue Circle. It therefore appears that on account of information not being provided by the circle officer, Gauhati Revenue Circle, the Bakizai proceedings have not been able to proceed. The circle officer, Gauhati Revenue Circle, is directed to take appropriate steps to ascertain as to whether MSAK Azad International,
AR International. Proprietor Heather Allen.
huh?
AR International.
AI International, or its proprietor, Sri Haidar Alam Azad, has any properties within his revenue circle and provide inputs to the certificate officer, Kamrup Metropolitan District, on or before 13th of March 2026. Mr. P.K. Medi, who assists Mr. B.J. Talukdar, the learned senior counsel, shall apprise the certificate officer, apprise the circle officer, Gauhati Revenue Circle, of the present directions. A copy of the instant order also be provided to Mr. P.K. Medi, the learned counsel, for necessary compliance. List the matter again on 13th of March. But you need to challenge that.
We will challenge by lordship.
Can I have this bunch of paper back? Take a video.
I think female na tarso koi. Yet koi le bad. Yeah, what is this?
Next. Tax ratio value.
What is your case?
My lord, the petitioner daughter was washed away by the flood and the flood during the flood situation.
Yes, what is your instruction?
Lordship, we are awaiting instruction, my lord. I appear for BTC, my lord. And also, my lord, the representations has been made, my lord, before the DC, my lord. So I'm not representing the DC, my lord. My lord, they may be the appropriate authority to answer. DC Chirang, my lord. As per annexures, my lord,
This matter has come up for orders.
for admission, my lord. For admission. The DC Baksa, my lord.
Now, who is to pay? Revenue. NDRF amount has to be paid by revenue.
DC, my lord.
DC,
Yes, my lord.
Yes, ma'am.
where is it mentioned? What have you not got?
We have made a representation before the DC, my lord,
Ah,
Baksa.
what is your representation?
Page number 27B.
With I'm an inhabitant of here. My daughter so and so studying in so and so, and unfortunately my daughter was due to death in flood. Is therefore prayed to you to find her due to death of year. So there is a scheme. Where is the scheme for death of flood year? Ex gratia payment to families of the deceased persons. The video regarding the norms of the
Annexures C, my lord. It's 70.
So you want to get 4 lakhs?
Yes, ma'am.
Okay, when did you submit this document? 2019.
My lord.
And then you have approached this court by filing the petition. Again, another representation given on 2019 or 2019. Then 2023. 23. Then you filed the petition in 2021. And this is of 2023. Okay. So who is to make the payment?
Payment is, my lord, DC is the authority.
How do you know? Huh? How do you know? The council, the problem is this. This is the government of India scheme. Payment has to be made by either the revenue department of the government of Assam, who is not a party. Payment is to be made either by there's nothing that the DC will make the payment.
My lord, it's the disaster and management is the revenue and the.
And why the Assam Disaster Management Department is not made a party?
My lord.
Huh?
My lord.
This should be paid by BTC. Yes, madam.
Lordship, regarding ex gratia payment, my lord, that has to come from the government, I guess.
The money will come from the central government.
From the government, yes.
Then,
Lord,
madam,
Lordship, we are-
what happens out here is that these people who are just asking this 4 lakhs, they are not getting things.
Lordship may issue direction.
Matter
then
of
we'll
two thousand
initiate-
twenty-three, we are in 2026. This type of matters I normally dispose of at the motion stage.
Lordship.
But here is a case after 3 years also, we are not getting any response. So better, therefore, we ask the Principal Secretary BTC to be present in person.
Or Lordship may issue direction, we will initiate to make payments, my lord.
What?
Lordship may issue a direction.
No, you are to consider on these facts whether it is true or not.
Lordship.
Then, and
Lordship,
whether
but-
the DC has informed or not. Where is the no government advocate is there? Chalo. If the government, who is the head of the government will be the Advocate General. We ask him to appear at 2. Then there is no government advocate being appointed out here to appear in the court. No government advocate, so we asked the alia. Okay, we'll have it at 2. Let the senior government advocate appear. Yes. What have you done in this case?
Lordship, actually, petitioner's charter falling under bond lordship, not washed away by the flood water lordship. That is why we are seeking some clarification from the revenue department lordship, whether he is entitled or not lordship. We are seeking some. That I can do. Just to miss school, then they have one. Working as a lady. I got it there.
File an affidavit
Lordship.
bringing on this, that he has fallen on phone, so that he has a right to reply.
Lordship. Lordship, we are seeking some clarification, Lordship. That we have seeking some clarification from revenue department, Lordship.
Huh?
We are seeking some clarification from the revenue department, Lordship. That is also there. We enclose. Lordship.
No, the question is, you see the petitioner, whether he is entitled or not, whether he or she is entitled to not, he has a right to know.
Lordship.
So you have to file an affidavit. It cannot take for the last 3 years, a matter can be pending.
Lordship.
When a matter is being taken up, Mr. N. Goswami, appearing on behalf of the respondent state, has placed before this court a set of instructions issued by the district commissioner, as well as district commissioner, as well as the circle officer, district commissioner Baksa, additional district commissioner Baksa, as well as the circle officer Boromar Revenue Circle, which are collectively kept on record and marked with the letter X. In the said instructions, it is being mentioned that the son of the petitioner expired on account of drowning.
That are.
in a pond on 17/7/2019 at Dalbari village near Ekalabya Model Residential School. Full stop. This court have duly perused the said instructions and therefrom it cannot be ascertained as to whether cannot be ascertained as to whether the respondents have rejected the application of the petitioner or not. Inasmuch as all these officers have sought for queries, had made queries upon the Revenue Department of the Government of Assam as to the petitioner's entitlement in terms with the scheme of the government of scheme of the Home Department of the Government of Assam, of the Government of India, dated 8/4/2015. Full stop. Both the Revenue Department of the Government of Assam as well as the District Administration are directed to bring on record their stand as to whether the petitioner herein would be entitled to the ex gratia payment. List the matter again on 18th of March 2026. In the meantime, the affidavits be filed by the Revenue Department as well as the District Administration on or before 11th of March 2026. Yes, what is your instruction?
Well, it is required.
Huh?
I got a specific instruction, but it is required.
It
That
is?
all these enclosures are to be submitted along with the.
How can you have a security bond submitted?
At least that format is to be submitted, my lord. They speak, the last para will speak for that.
At serial number 9, there is no mention.
Yes, otherwise, my lord, apparently it's not there, but my lord, this entire
First,
document.
have you
whatever is
taken
there-
no, first of all, have you taken the decision that you are going to release 50%?
My lord, for that, they say that, my lord, the CS certificate is necessary.
CS certificate was already given on 27/3.
That part, my lord, if lordship will say the speaking order, they say that it is not there in the record. For a moment, my lord.
But it is there in the records.
It seems so, my lord, in March 2014 itself that was provided. It's there in
Well-
the record. But it says, my lord, in the speaking order that.
No, speaking order, that is why she is challenging the speaking order.
Lordship. So they say, my lord, the CS certificate is necessary to ascertain the quantum of, my lord, benefit that the petitioner will get. What will be the amount?
No, oh, that is okay. But this is only, but here 8.1 is for release. But at the time of release, what is the requirement? The first thing, then, yeah, the first installment of the grant would be released after the firm has utilized 50% of the term loan as well as so and so on production of the following documents by the firm, duly security, so and so, so and so, so and so. But till that point of time, you have not taken a decision only that you are going to consider her application.
My lord,
Then
they say, my lord, all these appendix as well as, my lord, whatever is there in the appendix and the annexures, my lord, all are to be submitted, my lord, along with the proposal, my lord.
no, that you cannot. 9 does not say so.
Yes, 9 other required documents that are required to be submitted along with the application.
So that doesn't say so. And the fact that the certificate, the CS certificate was there is a matter of record. You have the records, no?
Yes, sir.
Okay, give the records. Madam, we make it CAV? We make it CAV? Because he is not the person, I have already dictated 75%. I only wanted to see the records, so the records are there. And I have already done with all my CAV matters, all will be delivered tomorrow, including Mr. Chaudhary's judgment. Hearing complete, judgment reserved. The records which have been produced by Mr. B. Gogoi is tagged along, be tagged along with the records of the present case.
I have flag marked the relevant documents, my lord. I have flag marked those, my lord, certificates that are there.
While was gathering dust, after finding out this restriction, they have done this.
That central government part also will clarify, my lord, that they will
No, I will therefore
provide
direct.
their part of the share.
No, I'll therefore direct the central government to
Constitute the committee again, my
to
lord.
constitute a committee for the purpose of looking into it,
Lots.
and thereupon shall proceed whether the petitioner is entitled to. I'm not saying that the petitioner will be entitled to how much, I'm not saying.
Yes.
They will consider by that committee.
But if your lordship.
But the rejection order has to be set.
This point, my lord, yes.
That some of the judgments, including the spine judgments, your lordship, if according to on this, you will get some very big funds. Because there is no reason, it was not rejected earlier.
And therefore, I'm saying the speaking order will set aside.
Yes.
There's no quarrel with that. I'm also setting aside, I'll say that the records, these is there,
Yes.
and there was no necessity of the security bond at that point of time. It is only necessary when the question comes for the release of the first installment. And Mr. B. Chakravarti appears na, for the government. No, Mr. Chaudhary, there's no problem with this, that I'm going to set aside that order. The setting aside of the order, the reason is that this was done behind your back without your notice. The only question of why at 4:45, 4:30 PM yesterday, I did not finish up the matter is how we take into consideration that as regards how the notice would be served upon you. Only on that aspect.
Now we'll accept notice. We'll accept notice. Lordship will fix a date for final consideration. At least Lordship will direct us to appear on a particular date.
I do one thing. The order can be treated as a notice.
Yes.
And I allow you to submit your representation.
Yes.
And thereupon, let it be heard, giving you a personal hearing.
Yes.
On this point. That would be the only thing. You are nobody.
My learned friend's client is otherwise nobody also, if a lordship will kindly have the act for a moment.
No, no, therefore,
Client goes, then he doesn't get as a number to there will be a fresh election.
be a fine.
in fact, Mr. Chaudhary, the thing is, I'm a bit surprised with how section 111 and rule 62 has been made. You see, normally,
There are
it's
incognito-
never heard of what has been done. That to remain. You have an electoral dispute which is done under 129. And you say that within this period you have to do it. The matter comes to an end. This is in terms with similar to 329.
Yes.
But how is it possible that you reopen something and you cancel elected representatives? Isn't it the most strangest?
Other than by way of an election.
Election.
So it is the most strangest of the proceedings. Never heard of.
Maybe someday some challenge would be laid, Miller. It affects the basic structure of the election code.
Absolutely. Because tomorrow, an executive, more particularly the power has been given to the district commissioner.
By people's vote, somebody is elected.
How can you, if somebody is aggrieved, he file an election petition, but 111 is a very dangerous proposition. I've never heard of this type of provision. And that is why you have a scope of scrutiny and all.
Yes.
So what is the scrutiny for? If you can pass through it,
I
then also
understand,
you are
They
given.
have also filed an election petition.
Huh?
They have also filed an election petition.
Oh, that's a different thing, election.
Not on this ground, of course.
Chalo. We allow your petition to that extent. Heard Mr. K. Chaudhary, the learned senior counsel, assisted by so-and-so appearing on behalf of the petitioner. Mr.
D.K. Roy, my lord.
So-and-so who appears on behalf of the respondent numbers 1, 2,
And
1
5.
and 2. School. And so 3 and 4, the 3 is who? District Commissioner? 3 and 6. 3 and 6, somebody has to appear. Register of birth and death. This will be the health. Where is health? I have seen Mr. B. Gogoi. He's 6. 3 is a government council. Mr. N. Gusami, you can appear 3. 4 and 5, you are there. Why not the 5?
My lord.
Oh, you appear for 5, no?
Yes, my lord.
1, 2, and 5. And 4 is him. So and so. The present petition has been filed by the petitioner challenging the order dated 20/11/2025, whereby the Secretary, Assam State School Education Board, had had cancelled the duplicate registration certificate, duplicate admit card, and duplicate pass certificate issued to the petitioner. The council, learned senior counsel appearing on behalf of the petitioner submitted that the registration certificate, the admit card, as well as the pass certificates which have been cancelled, have been done behind the back of the petitioner without issuance of any notice. And as such, the said order dated 20/11/2025 affects the right, ensures civil consequences upon the petitioner. The learned senior counsel therefore submitted that as the order dated 20/11/2025 had been passed behind the back of the petitioner, the impugned order is required to be interfered with. This court, by an order dated 9/2/2026, sought for instructions from the Standing Council of the respondent numbers 1, 2, and 5 as to whether the proceedings which led to the order dated 2011-2025 was initiated, as to on what basis the proceedings which led to the order dated 2011-2025 was initiated, and whether any notice was issued to the petitioner prior to the passing of the order dated 2011-2025. First, the learned counsel, Mr. So-and-so, who appears on behalf of the respondent numbers 1, 2, and 5, with all fairness submitted that the said order dated 2011-2025 was passed without issuing any notice to the petitioner. First, taking into account the above, it therefore appears that the order dated 2011-2025, which has the effect of cancellation of the registration certificate, admit card, as well as the pass certificate of the petitioner, was issued behind the back of the petitioner. And as such, the same cannot be allowed to be sustained in the law. Full stop. This court also finds it very pertinent to take note of that the allegation on which the instant writ petition stands is on the ground of violation of the principles of natural justice, inasmuch as the petitioners, inasmuch as the impugned order dated 2011-2025 was passed without granting an opportunity of hearing to the petitioner. Taking into account the above, the instant writ petition therefore stands disposed of with the following observations and directions. The impugned order dated 2011-2025 is set aside and quashed. Number 2, the petitioner shall treat the order dated 2011-2025 as a notice to the petitioner, and within 15 days from today shall submit his representation / reply to the Secretary, Assam State School Education Board. Full stop. Upon receipt of the full stop. This court further observes and directs that if such reply / representation is submitted within the period aforesaid, the Secretary above directed, the Secretary Assam State School Education Board shall fix a date for hearing, thereby giving the petitioner an opportunity of personal hearing. Thereupon, the Secretary Assam State School Education Board shall dispose of the said representation / reply by passing a speaking order. In view of the order passed in so and so, I things to do. Where is Mr. B.D. Kumar?
Lordship, may kindly pass over the matter for the time being. Senior is on lag on court number 9, Your Lordship. That matter has resumed after lunch break. The matter that will take Lordship hardly 15-20 minutes more.
Okay. You wait.
Double fact for it will take on this one and technically for registered officials
Yeah. I should say. Order to থাকো। Oh, yes. What is this? I am now going to exercise an original jurisdiction. There is many I's also. Let us see.
We'd like to take up the IS first. There's a prayer for amendment of the
Which is the IA?
IA 384,
Huh?
384 of this 26.
384
And
of
identical IA, which is
2026.
427.
What is this application for?
So this for amendment of the counterclaim, just the prayer and the counterclaim.
Who is the counterclaimant?
I'm the counterclaimant.
What do you have to say?
On the last date, it was noted that consequential relief had not been sought by me in my counterclaim prayers. Those consequential reliefs, which is of revocation itself, and under section 151 of the Patents Act, if an order is passed in my favor, it has to be sent to the controller, who will then make appropriate entries into the registry. So those will be the consequential prayers, if I'm successful.
Okay. Has he filed a written statement?
No, not yet.
Written statement? No. So we can allow this? This is an application filed under Order 6, Rule 17 of the Code of Civil Procedure, read with Section 151 of the Code of, under Order 6, Rule 17, read with Section 151 of the Code of Civil Procedure, 1908, seeking amendment to the counterclaim filed by the petitioner, by the counterclaimant. Mr. B.J. Mukherjee, who appears on behalf of the plaintiff, submits that he has no objections to this instant application. First of taking into account the above, the instant application stands allowed. Now, taking into account the first of this court have also taken note of that in pursuance to the counterclaim so filed by the counterclaimant, the plaintiff is yet to file the written statement. Under such circumstances, in addition to that, the relief which have been sought to be inserted by way of the present amendment application, in the opinion of this court, being consequential to the relief which has been sought for in the counterclaim, is necessary for adjudication of the dispute involved in the present proceedings. Accordingly, this court therefore allows the instant application, thereby permitting insertion of prayers 3 and 4, thereby permitting the amendment as sought for at paragraph number 6 of the instant application. The counterclaimant is directed to file, is given 14 days time to file the amended counterclaim in terms with Order 6, and failure to do so, consequences under Order 6, Rule 18 shall ensure. I stands disposed.
Your Honor, there's an identical I, 427. The same order may be passed there.
What is that?
It's identical. There are two counterclaims I've filed. So this is
Why are you filing two counterclaims?
because I'm representing two parties. Three. So both of them have preferred counterclaims.
Well, on dispose, same.
In fact, the other IA, 3021. There's an IA 3021 of 25.
Where is 3021? Who was any idea?
That was an application for injunction, Lord.
Where is that? IA ko to say to. Number is any?
302.
No, 302.
3021. Yes. What is that?
It's an application for injunction.
Who are you?
Huh?
Who are you?
I'm defendant 5.
You have filed an application for
No,
injunction.
Lord, they have filed, but perhaps that's become infructuous because the patent has expired. The patent has expired.
Where is the application? application করে বিষয় না পারে। এই এহেঁতি ৰেকৰ্ডছ মেইনটেইন কৰিব নাজানে নেকি? ট্ৰায়েল কোৰ্ট ৰেকৰ্ডছ কেনেকে মেইনটেইন কৰে?
I have a copy of that.
3021. Where is that application? Picture from 1 to 15. What is it? এখন petition বেলেগ হ'ব।
Internet page seven.
এইটো দিয়ক। এখন বেলেগ হয়। Order 39, rule 1 and 2 for
Prayer is at page
It's
17, 17.
From infringing and violating the patent bearing number and making unauthorized use of the same without the consent of so and so. No patent?
Patent has expired. It has expired on 13/5, so this IA would be infracted.
So we close it with liberty. If you get a patent, you can be very well.
That liberty perhaps would not be required, because once a patent expires, there is no scope for renewal. This suit will now run as a money suit for the other players that have it.
Okay. Now tell me one thing. If your patent is expired, what is the claim for compensation you ask? Okay, claim for at that relevant point.
At that, there was a tender that was.
And you have a counterclaim.
Yes, so actually, if the revocation takes place, then the consequence of that is that his name will be struck off. Then it operates in rem, so all claims actually collapse. It's because it's as if he never had a patent. So consequently, there can be no money claim.
And what is your counterclaim?
My counterclaim is on the point that the patent should never have been granted to begin with. Technical grounds on why it ought not to have been granted.
And
for
what is
example,
your claim?
Lord, I'm just defending because under section 107, I can take up all the grounds that are available under 64, including revocation of the patent.
So you are the defendant number 5.
Five.
And what is he asking for?
He was initially asking for injunction to infringe and besides that compensation. Now the prayer for compensation of course would remain, but injunction will not survive.
Injunction won't remain, so prayer for compensation.
Compensation will survive.
Now he's asking the compensation from you.
All of us.
all of
jointly.
jointly.
You also.
No, he's with.
You.
She's with me.
PPCL is also there.
From you also. You have filed your written statement. All of you have filed.
We filed.
All that is complete.
So you filed a counterclaim.
Yes.
Issues framed.
Not fair. Written statement to be filed. Written statement is to be filed to the counterclaim.
Mr. B.J. Mukherjee, the learned counsel appearing on behalf, heard Mr. B.J. Mukherjee, the learned counsel appearing on behalf of the applicant. Who are the other respondents? Who appears for Apurva?
I am for Purva. I am for 2, 3, and 4.
You are
Aprava.
appearing, Mr. Das, you are appearing for whom?
I am for 2, 3, and 4.
Who appears for 1?
APDCL.
You are APDCL. Apurva Energy Private Limited is APDCL.
Perhaps my lord has a counterclaim. Injunction, APDCL will not work.
Okay, he doesn't appear. Who appears for Apurva?
I am for Aprava.
So that is what I am asking.
So
You only-
Aprava, Hyprint, and Genus. So 2, 3, and Aprava, Hyprint, and Genus. These are my.
Mr. DJ Das appears on behalf of the respondent numbers 1, 2, and 3. Adani,
Adani Amin, sir.
Mr. So-and-so appears on behalf of the respondent number 4, opposite party number 4. The present application has been filed by the petitioner, applicant, oblique plaintiff, seeking an injunction, temporary injunction restraining the opposite parties, their men, agents, assigns, etc. from infringing and violating the patent bearing number 208216 and making unauthorized use of the same without the consent of the petitioner. It is being submitted by Mr. B.J. Mukherjee, the learned counsel appearing on behalf of the petitioner, oblique plaintiff, that the patent bearing number 208216 have been cancelled,
Expired.
had expired. So, taking into account the above, the question of granting any injunction in the present proceedings does not arise. Accordingly, the instant application stands dismissed, stands rejected. I closed. It main khonot likhibo. You file here, list is that hey dukhon application dukhon ase na dispose koril na. In view of the orders passed in IA number so and so and IA number so and so, the respondent numbers, the defendant numbers 1, 2, and 3.
2, 3, and 4.
Who has filed the counterclaim?
I am filing the counterclaim.
I
Oh, 2 and 3.
Is
Two and-
it
two and
the
three.
who?
2 and 3 on.
So you therefore say I don't say I. What is this I business? The defendant number 2 and 3 who had filed their respective counterclaims. In view of the order passed in I number so and so, comma, the defendant number 2 and 3 are directed to file the amended counterclaim. Adi ki tarikh? 17th. 1, 2, 3, 4, 5, 6, 8, 9, 10. On or before 5th of March 2026. List the matter on 5th of March 2026.
In fact, the other IA also, your lordship can close, we are not pressing it. 3022. This was filed by us because they had filed it before the district judge. We said that it's a commercial dispute and it should go there. Now that it has come here, we'll not press that.
3022. You filed it by 5th.
Absolutely.
I'm listing it on 5th because then I'll fix a for written statement file. 3022. Two. Heard Mr. B.D. Dekar, the learned counsel who appears on behalf of the defendant number 5, public applicant, and Mr. B.J. Mukherjee, the learned counsel who appears on behalf of the plaintiff, oblique opposite party. This is an application filed for rejection of the plaint or return of the plaint on the ground that upon filing of a counterclaim in a proceedings filed under Section 104 of the Patents Act 1970, the district judge, Kamrup Metro, did not have the jurisdiction to entertain the said proceedings. Taking into account that in pursuance to orders passed, taking into account that in the meantime, in terms with section 104 of the Patents Act 1970, the matter has been laid before this court, comma, nothing further survives in the instant application. According, the said application stands dismissed, rejected.
Deeply obliged.
Right.
Lord, only one petitioner is a Masjid, represented by the committee. So my Lord, the notice is similar. Lord, I have annexed a page, Lord, the last page. 71, Lord, in fact, there is a, process has been undertaken, government asked us to, submit in terms of the Bosundhara 3.0, my Lord, may kindly turn. Page 40. Page 47, 37, The translated copy, original one is at page 38, vernacular, sir.
So you applied here.
Lord, in fact, we responding to this notice, Lord, we did not, but prior to this in the year, my Lord, may kindly turn to page 39, these applications we have checked, still pending. Lord, before the authorities at page 39, annexed 3, Original one is at page 40,
So you applied in pursuance thereto.
My Lord.
Then?
Then, my Lord, nothing has been done. Now, my Lord, they have this eviction notice has been initiated. So, my Lord, everything can be, we can place before the authority, my Lord, in terms of my Lordship's order, my Lord. Similar line, if my Lordship is pleased, my Lord, can be disposed of, my Lord. The other order I have annexed, my Lord, is at page 58, annex of 5.
Mr. Bhuya, read what is there in page 32. What is the name of that document?
Page 32, my Lord.
Huh?
Deed of, my Lord, sale of land, my Lord.
No, read it.
My Lord.
Read the SMS.
Page 32, my Lord.
Huh?
Jami Dokhal Sotto Bikri Dolil.
So, what you have, what is the document is not deed of absolute sale of land. Deed of sale of possession of the land.
Possession, that is correct.
This is a wrong translation. This is the second translation I have
My
seen.
Lord, I seek apology for that, my Lord, what, my Lord, some hurry, my Lord. I'm sorry for that, my Lord.
But this is the second one, na?
My Lord.
Yesterday also the same document type is there.
My Lord, my Lord.
Disposed.
Obliged, highly obliged.
Who is appearing for revenue? No revenue council. Main submission is of revenue, no revenue council. Should we note that the revenue is not bothered any further? Huh? Revenue is equal, say, in order to N Goswami equivalent. Huh? Revenue karne kumbata dhoi rakha bhai. আৰু যোনটো গভৰ্ণমেণ্টৰ এডভোকেটে কৈছে নহয় এইটো ৰেভিনিউ কোৱা বুলি ৰেভিনিউ এন বৰ্ড লৈ জে হেণ্ডিক ইজ জে হেণ্ডিক Mr. R.S. Mishra, what is this?
Well, sometime we get to file affidavit. Time will get some time. I received the inspection.
Petition is non-refund of interest on maintained and what is the age of the person?
82 years, and this it was filed last year, madam. Is the HUF, madam, is the Karta of,
What has happened here?
madam.
What has happened?
Department is less amount of maturity amount, madam, that's why the.
Huh?
Postal department has released, madam, less amount, madam, maturity value, madam.
Why?
But they are relying upon a circular, madam, but see, this account was opened in 1990, madam. This passbook was.
So in the account it is mentioned, so your calculation is wrong. How much it should be?
More than 1,92,000, madam. The passbook was updated till, my lord.
Please kindly include here with the
41,
xerox.
my lord.
So wherein it is clearly mentioned that the due amount is so and so. How much you have been paid?
In fact, my lord, 1,41,000, my lord. No, my lord, my claim is more than this 1,92,000.
Now who is, you are paying for the chief postmaster?
Yes, all men.
So who is to pay the cost for the delay in not filing the affidavit?
My lord, today I received the instruction, my lord. I'll file.
What is your instruction?
My lord, it is not ready, my lord. So,
You say that you have received the instruction.
yes,
What
my lord,
is
is. Some, not person. Page second is not readable, my lord, so I printed. Only there, my lord, is it is open, it is not opened by respondent 5, it is opened by respondent 6, my lord. So I'll take definite instruction, my lord.
When did you close the account? Huh?
2025.
2025 you closed the account.
Yes, ma'am. Sorry, ma'am, 24. I'm sorry.
Huh?
24, sorry.
So your basic case is that interest is not admissible in respect of HUF account after 31/12/2005 as stated in the case of the case. That's your instruction.
Yes.
Huh? And you are blaming the postal employee.
Yes, man, that is there. I've seen man. I've seen man today, man, they're blaming another employer, respondent 5, 6, man.
Then?
So I've taken instruction, man, because this morning I received mail.
So 10 days?
10 days, mail, yes.
File your affidavit within 10 days and then we have it on 11th
11th of
March. The petitioner herein is aggrieved on account of non-payment of the amount to which the petitioner is entitled to. Under the National Savings Scheme 1987. This court issued notice on 6/6/2025. However, the respondents, in spite of receipt of notice, have not taken steps for filing any reply. any affidavit in opposition. Considering the above list this matter on 11th of March 2026. A final opportunity is given to the respondents to bring on record their stand by filing the affidavits on or before 5th of March 2026. This court duly takes note of that the Karta of the petitioner is an 82-year-old senior citizen and delay in disposal of the instant writ petition would be contrary to the settled directions passed by the Supreme Court. Accordingly, list accordingly.
But is petition for enhancement of the awarded compensation to the petitioner. Now kindly see for page 33 kindly see.
Where is your application?
Yes, page
Page
33.
79.
Huh?
79.
First page 33.
Application.
Yes.
Yes. Page 33 Lordship will find first assessment was 5 crore 20 lakhs 4,294.
Page?
Page 33.
33 doesn't have 5 crores. No 5 crores is there. Where is 5?
3.
Huh?
Page 33.
No 5 crores. 30?
3.
33 doesn't have. 33 is different, Annexus 6.
Yes, Annexus 6.
It's a notice dated 15th
Yes,
May 2020.
will find the amount.
LA case number so and so award 64, awarded amount is 5 crores 20 lakhs 4,294.
Yes.
Then-
Then Lordship kindly see page 73. Page 73 Lordship will find last Muller 55 lakhs 87,902. That amount has been accepted by the petitioner on protest. And thereafter, he has filed application under section 64 for enhancement of the awards.
Where?
Yes.
Page 79.
That Lordship will find at page
79.
79. That petition is pending before the district commissioner till date. No steps has been taken. Page 79.
Now tell me one thing. This is done under what provision?
Under section 64 of the act. If anybody is aggrieved, not dissatisfied with the award of compensation, he can file an application before the district commissioner.
Fantastic.
And the district commissioner.
When will section 64 come into play?
Yes.
When?
It says, I am reading the section.
When? When an acquisition is made under the Right to Fair Compensation Act. Is the acquisition made under the Right to Fair Compensation Act or is it under the Assam Land Requisition and Acquisition Act?
It is under the 2013 Act.
Huh?
2013 Act.
No. The compensation will be paid as per 2013 Act in view of section 109. But your acquisition is being made as under the Assam Land Acquisition and Requisition Act.
Yeah, 64.
So then under what provision you should have filed it?
Now, section 64 says,
You have to file it under section 12 of the Assam Land Requisition and Acquisition Act 1964. Do you have it? Did you get one?
Now, I thought, my understanding is,
Please don't think so much. Because your notice, kindly see page 33. It is hereby informed that you that the above noted LA case number so and so, the below scheduled land have been occurred.
Yes.
The said land would be taken over possession under at Iman at as per section 5 and 4 of Land Acquisition Act 1964. So this is done under the Assam Land Acquisition and Requisition Act.
Yeah.
So section 12. So we direct within 1 month to make a reference, Mr. Goswami, treating this as an application under section 12 before the judge, before the district judge, Kamrup Metro,
Dhubri.
huh?
Dhubri.
District Judge Dhubri. What is wrong? Why they are not doing it? And also pay cost. Okay. You pay cost to him for filing the instant writ petition, a thing which you were bound to do because the word is used is shall in section 12. Section 64 also says shall, meaning thereby you are not to decide how much once the award is passed. Okay? So, Mr. Mondal, how much you have taken?
Lord, we have taken Lord 3 crore 55 lakh.
No. You. How much fees you have taken?
So,
That you claim it from.
well,
Heard Mr. M.U. Mondal, the Land Council appearing on behalf of the petitioner. Mr. N. Goswami appears on behalf of the respondent number 2
Two,
and
three,
2, 3.
six,
Because
seven.
why have you made all these people a party? The
Somebody-
problem is this. If the land is acquired, why you are making this a Kala party? Kala, the moment you make Kala a party, it goes to the National Highways Act. Highway has Kala. Then you have made the NF Railway a party. Why?
the land was used by the Lord NF Railway for making Lord overbridge.
So then you make LF Railway a party. You make the subdivisional officer a party. You have made the circle officer a party. And who is number 8?
Private response.
Why?
Because he is objecting
Two?
the award of compensation.
It's another aspect. He has to file an application. Do you want to make him clever? Huh? Then he can file an application under section 11. Right? You have filed it? You file? And so you don't make all these people unnecessarily a part. And so appears on behalf of the respondent number 2, 3,
6 and 7.
6, 7. Mr. J. Hendig appears for respondent number 1. Mr. S.S. Roy appears on behalf of the respondent number 5. Mr. So-and-so appears for respondent number 8. 8.
Yes.
The petitioner herein has approached this court being aggrieved by the inaction on the part of the respondent number 2 in taking steps for making in failing to refer the dispute pertaining to enhancement of compensation as is mandated under law. This court duly takes note of that the acquisition has been carried out in terms with the Assam Land Requisition and Acquisition Act 1964. The land acquisition proceedings is registered as LA case number 1/2022-23. The materials on record further show that the grievance of the petitioner herein is that earlier the petitioner was issued a notice that the compensation to which the petitioner was entitled to was rupees 5 crores 20 lakhs 04294. However, subsequently, it has been determined that the petitioner's compensation is rupees 3 crores 55 87 902. It is the case of the petitioner that the value of the land as well as the buildings standing thereupon have not been taken into consideration as per the mandate of the Right to Fair Compensation Act, and more particularly, Section 26 to 30 of the said Act of 2013. It is under such circumstances the petitioner therefore filed an application seeking a reference on 21/4/2025. This court have heard the inaction on the part of the respondent number 2 to make a reference have constrained the petitioner to approach this court by filing the present writ petition. It is noticed that upon filing of the writ petition on 3/9/2025, notice was issued, and specifically observing that a pendency shall not be a bar upon the respondent number 2 to act on the application of the petitioner, which, however, act on the application of the petitioner strictly in accordance with law. Today, when the matter is being taken up, no instructions have been placed.
Some instructions received, Lordship.
What?
Because there is some reassessment has been done, Lordship. They understood that they have already done the reassessment because in the application he has filed before Deputy Commissioner, his prayer was to reassess the compensation, Lordship. They understood that they have already reassessed, Lordship. Initially it was 5 crore, subsequently it was reduced to 3 crore something. Lordship.
Then he's asking for enhancement. Have you passed the award or not? Today, when the matter is being taken up, this court sought for instructions as to why steps have not been taken in pursuance to the communication dated, the representations, the application submitted by petitioner on 21/4/2025. Mr. N. Goswami, the learned counsel, submitted that the district commissioner Dhubri is still reassessing.
No, already reassessed, Lordship.
Have you passed an award or not? Have already reassessed. Under such circumstances, this court inquired as to whether any award has been passed, which is the requirement as per law. No information in that regard have been placed. Considering the above, list this matter again on 23rd of February 2026. The respondent's hearing, more particularly the District Commissioner, Dhubri, shall apprise this court on the basis of instructions as to whether an award has been passed in respect to LA case number 1/2022-23? And if so, to produce the said award on the next date. Mr. Gusami, I don't understand. What is this? Isn't it the fundamentals of land acquisition that you have to pass an award? How can a matter be, how can a petitioner be asked to come twice or thrice before this court? This is the second time the petitioner has come. So, this time fees, earlier fees, calculate and come up with on 23rd. We ask the DC to pay as well as otherwise from Mr. N. Gusami. It can't happen like this. I don't understand, Mr. Gusami, this is not done. Are you land acquisition officers aware of what is required to be done under the Land Acquisition Acts? Have you your possession taken? Possession. That means there has to be either a possession taken under, if it is done, it has been done under Section 5, possession has been taken. If you are possession taken in that regard, the interest will be accumulated from then. Have you taken note of all these things in your award?
I'll take instruction.
And if you have not passed the award, and thereby we are asking you to return the land to him. No award. Tell your deputy commissioner.
I was in Lex for the first call I could not get it.
Okay, Mr. Kaur,
Yes.
what do you have to say?
Your Lordship has seen the dismissal order at page 91. Now, if your Lordship looks into the dismissal order, it says Mr. So-and-so appeared before me for personal hearing on 31/2025. After hearing the oral submission made by him, I found that he has not brought us any new material facts except what is already on record. I therefore inflict the punishment of dismissal in terms of rule number 67J of SBI OSR on the charge sheet office. The suspension period is to be taken as on today. However, the substance allowed drawn during the subsequent period did not be recovered from the official. Then your lawsuit will see the allegation at the top, allegation in brief is said that he had not adhered. The last line of the allegation in brief your lawsuit will find. He had not adhered to the systems and procedure and did not discharge his duty with utmost honesty, integrity, devotion, and diligence, and thereby tarnish the image of the act. Then the inquiry officer on conclusion of the proceeding had submitted his findings against each of the three allegations raised against Mohammed Mafizur Rahman, to which I has found all the three allegations as proved. The disciplinary authority had concurred with the findings of IA, which was communicated to the CSO, as mentioned in 4 above. I have examined that, I observed the irregular lapses consequences also. So this is the order of at page 91, which for the time being your lordship will presume is to be correct. Now your lordship will see the appellate order. At page 100 is the objection.
100?
Page 100.
Yes.
Last paragraph. I therefore don't feel it necessary to interfere with the decision of the appointing auditor, imposing penalty of dismissal in terms of Rule 67J of SBI OSR inflicted upon Mr. Saikia, and the suspension period to be treated as not on duty, and the substance allowance drawn during the suspension period will not be recovered from the officials. Even this also your lordship will presume that it is correct, because the standard of dedication, diligence, or of a bank official that is required is different from an ordinary employee. Now, the only this during the pendency of this petition, madam, unfortunately the petitioner expired, and we had filed a substitution of the legal hires only on the ground that even if this, even if this both these orders, your lordship holds that it is that this dismissal order is valid, then whether the monetary benefits can be given to the legal hires of the deceased. That is the only question which has to be determined by this honorable court now. Now you'll also see, so far gratuity is concerned, they have not paid anything, taking the plea of the sub judice of this matter, they have not paid anything. As per my instruction that you, my learned friend, will have the, nothing has been paid. So gratuity, to forfeit the gratuity amount that which I have earned, there has to be a financial or pecuniary loss to the bank. Here your loss will find from the inquiry that no financial or pecuniary loss has been caused to the bank. So gratuity, to forfeit the gratuity, the bank can always do if on the basis of my misconduct, if financial loss has been caused to the bank. Here this is not the case that any financial or monetary loss has been caused to the bank. The other dues which I have earned by dint of my service for 30 years, those dues are also to be paid to me. And now the only question that which has to, your lordship has to determine is that whether the pension, in view of the order of dismissal, is payable to the legal heirs of the deceased. Now, so far pension is concerned, madam, the SBI has their own State Bank of India's Employees Pension Fund Regulation 2014. And Rule 14 says when pension can be forfeited.
What are the rules?
SBI Employees Pension Fund Regulation 2014. That's what they. Online. Now your lordship will see the circumstances on which the pension can be forfeited is at Rule 14. It is only if there is a finding or there is an in the inquiry or in the impugned orders of the authority, madam, that an employee dismissed from the bank service for willful neglect or fraud. Here your lordship will not find anywhere in the inquiry report that the word willful neglect has been used or fraud has been pleaded. It is only under these two circumstances the pension can be forfeited.
Now, if allegation number 2 is said to be proved, isn't it a case of fraud?
There is no specific term used.
Kindly, you don't need to, kindly come to page 98. 98.
Yes, I'm on page 91.
Allegation 2.
Yes. On investigation, it is revealed that you insisted the complainants to collect money at rupees 5,000 each from the villagers who are interested to avail KCC loan. The amount so collected will be the bank as SDR in the individual name of the villagers, but subsequently neither SDR were issued nor any agricultural loans were sanctioned to the people concerned. As per that statement, you have taken money, but neither the amount was returned, refunded, nor any loan has been sanctioned to the people concerned. Copy of loan documents such as application, appraisal, etc. signed by you are found undated, undated, blank, incomplete in some cases, found with the complaints complaints applicants.
Allegation 3.
You have signed loan documents indiscriminately outside office premises without prior consent of the competent authority.
So 2 and 3. 3 would be willful neglect, 2 will be fraud.
My lord, with utmost respect, I'll like to inform my lord because here you have to specifically state that it is willful and fraud. And when my lord, your lordship will place one judgment, just recently, my lord, similar circumstances, where there was a specific provision for forfeiture and the single judge passed the order in favor of the petitioner. The bank went on appeal. The bank ultimately, the appellate court upheld it. Here, this provision is, your lordship will first see, I'll take the division bench later. Your lordship will first see the single judge order. Paragraph number 9, your lordship will see the forfeiture of service. In spite of this one, your lordship will see Regulation 22 of the regulation, which is relied on to deny the claim of the employee, reads as follows. Forfeiture of service. Resignation or dismissal or removal or termination of employee from the service of the bank shall entail forfeiture of his entire past service and consequently shall not qualify for pension service, which is more stringent than the provision at Rule 14 of the SBM. Now, from the plain reading of the aforesaid regulation, it is evident that removal of an employee shall entail forfeiture of his entire past service and consequently such an employee shall not qualify for pension benefit. If you accept this submission, no employee removed from service in any event would be entitled for pensionary benefits. But the fact of the matter is that there is a bipartite settlement provides for removal from service with pensionary benefit, as would be due otherwise under the rules or regulation prevailing at the relevant time. The consequence of this construction would be that the words quoted above shall become a dead letter. Such a construction has to be avoided. The regulation does not entitle every employee to pensionary benefits. Its application and eligibility is provided under Chapter 2 of the regulation, whereas Chapter 4 deals with qualifying service. An employee who has rendered a minimum of 10 years of service and fulfills other conditions only can qualify for pension in terms of Regulation 14 of the regulation. Therefore, the expression as would be due otherwise would mean only such employees who are eligible and are putting minimum numbers of service to qualify for pension. However, such of the employees who are not eligible and have not put in required number of years of qualifying service shall not be entitled to the superannuation benefit though removed from service in terms of Rule Clause 6B of the bipartite settlement. Clause 6B came to be inserted as one of the punishment on account of the bipartite settlement. It provides for payment of suits. This bipartite settlement is also applicable in case of SBI. It is in case of SBI. We have to look into that bipartite settlement also to see how it has dealt with it, because all the banks were party to it. The bipartite settlement tends to provide a punishment which gives superannuation benefits otherwise due. The construction canvassed by the employer shall give nothing to the employees in any event. Will it not be a fraud, bipartite settlement? Obviously, it would be. From the conception of what we have observed, we have no doubt that such of the employees who are otherwise eligible for superannuation benefits are removed from service in terms of Clause 6B of the bipartite settlement shall be entitled to superannuation benefits. This is the only construction which would harmonize the two provisions. It is well settled rule of construction that in case of apparent conflict between the two provisions, they should be so interpreted that the effect is given to both. Hence, we are of the opinion that such of the employees who are otherwise entitled to superannuation benefits under the regulation, it basically with the penalty of removal from service, which superannuation benefits shall be entitled for those benefits, and such of the employees who visited with the same penalty but are not eligible for superannuation benefits under the regulation shall not be entitled to that. The law laid down in case of SK Pool has been followed in another recent decision of the Supreme Court rendered in the case of Vijay Kumar Nanda, thereby expressing a similar view in the matter. There is no wrangle at the bar that the law laid down in the case of SK Pool and Vijay Kumar Nanda would be squarely applicable in the case of the petition. If that be so, the court is of the unsistent opinion that there is no scope for the court to accept the objection raised by Mr. Sharma, placing reliance on Clause 22 of the regulation. On the contrary, in view of the decision of the Honorable Supreme Court in the case of SK Cool as affirmed in Vijay Kumar Handa, this court is of the opinion that the petitioner who has rendered more than 29 years of continuous service in the bank and being otherwise eligible to receive pension under the rules cannot be denied the benefit of pension merely by relying upon Clause 22 of the regulation. For reasons stated above, this petition succeeds and is hereby allowed. The respondent bank is directed to compute the pension as well as other terminal benefits payable to the petitioner in the light of the observation made above hereinafter and release the amount as expeditiously as possible, but not later than 3 months from the date of receipt of a certified copy of this order. Also consider the prayer made by the petitioner's counsel for grant of interest. It may be correct that there was some delay on the part of the petitioner in furnishing some documents to the bank so as to process the release of his retirement benefit. However, there is nothing on record to justify the delay of more than 17 years on the part of the bank in releasing the terminal benefits or aggregate use of the petitioner. In this crucial 17 years, the petitioner has undoubtedly been deprived of the benefits of his retired terminal dues, which are payable to him by the bank under the rules. On the contrary, by failing to pay the amount to the petitioner, bank has made monetary gains in the form of interest accruing on an amount which amount did not belong to the bank. Therefore, having regard to the peculiar facts and circumstances of the case, and by balancing the equity, it is hereby provided that the amount found due and payable to the petitioner under the order of this court shall carry interest at the rate of 6% per annum after deducting the period of 6 months from the date on which the same becomes due. It is further made clear that the amount payable to the petitioner is not released in full within 3 months from today. The outstanding dues would carry interest at the rate of 12% per annum with effect from 4/3/2008 till realization. Now, against this order, my lord, the bank went on the appeal. Your lordship will kindly see the order of the Honorable Division Bench. Wait, this intercourt appeal is directed against the judgment on order dated 1/5/2025 passed by the learned single judge in WPC number so and so, whereby the writ petition filed the respondent was allowed and the appellant bank was directed to release the retirement terminal benefits to the writ petitioner. The brief facts are the respondent was initially appointed as a clerk at UCO Bank in 1978. He was subsequently promoted to the Officer Cabinet. In 2008, pursuant to a disciplinary proceeding, the respondent was removed from service by order dated 4/3/2008. The removal order was unsuccessfully challenged before this court and attained its finality. Therefore, the respondent filed WPC number 5939/2014, seeking a writ of mandamus directing the bank to release his terminal benefits, contending that the removal from service did not automatically disentitle him from receiving the superannuation benefits otherwise due under the extant service regulation and settlement. The bank insisted that the writ petitioner primarily on the ground that under Regulation 22 of the UCO Bank Employees Pension Regulation 1955, hereinafter referred to as the Regulation 1975, removal from service entities, forfeiture of past service and consequently disqualifying from pension. Means if the past service is forfeited, that means the qualifying service goes. That's why the pension is not payable. That was the ground taken by the bank. It was contended that once the respondent was removed from service, his entire past services stood forfeited and he was not entitled to the pension benefit. The learned single judge, relying on clause 6 of the bipartite settlement and regulation 20 of the regulation of 1995, and also placing reliance on the decision of the Honorable Apex Court in the case of another reported in so-and-so, as well as subsequent decision of the Honorable Apex Court in the case of UCO Bank and another versus Vijay Kumar.
Mr. Kumar, do you have, there are two questions. First, do you have a bipartite settlement in that regard?
Yes.
Where?
Well, all the banks were party to it. All the banks were party to it. I can place it on record by filing a charge. Because all the banks were party to it. That's why this honorable court, because I have also to see, madam, because last night
Where is the bipartite settlement?
Yes, there's a bipartite settlement.
Show me.
Madam, I have to bring it on record by filing an affidavit.
You show me.
Your
There are two
lordship will
things.
be-
That is one.
Yes,
Secondly, if you see the earlier proceedings before the single judge in that matter,
yes, ma'am.
the dismissal attained finality, the removal of service attained finality.
Yes.
That is one aspect.
Yes.
Then there was a separate writ petition filed, wherein there is a direction sought for that merely removal for service with superannuation benefits. As per 6B, I can get it. So by 22, you cannot remove me, so and so. Removal from service and termination from service are also two different aspects. So that is one. In the instant writ petition, you are only challenging this aspect, that as regards termination order which have been passed, dismissal order which have been passed. So why should we go into that
Yes.
aspect?
First is, madam, your lordship has said that we have assail the order of termination. Because if the order of termination during when the petitioner was alive, if those orders have got, the other consequential benefits will forfeit. Now, during that time when he died, we filed the IA seeking only for the monetary benefits only. Because now those, even if the orders are set aside, it will have no benefit. We are only concerned with the IA number 104 of 2020-21. The order
You only sought for substitution?
on the ground of monetary, paragraph number 6 of the Act.
That is different, but you only sought for substitution.
Yes.
So,
And otherwise, my lord, if your lordship else, that is dismissal order will stand the scrutiny of law because it relates to the bank and all those paraphernalia terms used in the different judgment that the bank employees conduct should be beyond reproach. But even then, I will respectfully submit the judgments of the Honorable Supreme Court that in a case of this nature where a person has died and the consequential reliefs like the superannuation and all, because of the long pendency of the case, the court can always mount the relief. That I need not tell your lordship.
how do I mount the relief the way
So
you have
mount
never
the relief
asked
is-
for?
No, the
You have
mount-
never asked that relief.
No. And they ask for the pension. But once your lordship helps, then your lordship can observe in this case itself that so far pension and the other retirement benefits are concerned, it is payable to the deceased widow.
Absolutely no. This is not your pleadings at all.
Because your lordship will say, I can instead why this has been allowed in some of the cases. Because to avoid multiplicity of proceedings.
No, it's not a question of multiplicity. Here, my question before me is this as to whether the termination, the appointment orders, the termination or the dismissal orders are within the purview of exercise of judicial review by this court. Materials on record, so it is not so. So as of therefore, as on that date, you may pursue. You may have a liberty. I can give you a liberty for filing another writ petition seeking the benefit as per 22, whatever it may be, but not in this proceedings.
What I was coming. Even this dismissal order, madam, your lordship has sent out. What was the order?
Well, you have to bring your case. You see, in the earlier case, round of litigation, that proceedings also, there was a petition filed. It has attained finality as regards the termination, but there is now the question is when it is a case of removal with superannuation benefits, 6B has been interpreted that merely removal from service on the basis of clause 22, you cannot hold it that he is not entitled because you have already agreed by way of a bipartite agreement. But that is 22 is on 6B is only for removal. Removal is different from dismissal.
Well, something that even if your lordship else, which I was also saying, that even if your lordship holds that the dismissal order is valid in the eye of law, the appellate order is also in consonance with law. Even then, your lordship can whether it can grant or observe that the pensionary and the other retired benefits are payable in this case. I'll reflect on it, Malak, tonight. I'll come after 1 day. Your lordship.
No. Today,
48 hours. I'll give it to your lordship that option to and because those are not because your lordship knows that pension can't be denied by pendency of this case. They have not given it to us. This is a person, Malak, where widow is before your lordship, Malak. Your lordship will see that.
Mr. Kaur, I have full sympathy. I have full sympathy for the family.
No.
I have full sympathy for the family. Because of some conduct of the husband, the family is not suffering. I have full sympathy. For which liberty I will give it to you for that. But that is a case which have to be made out in a separate facts of case.
With utmost respect, I will submit my
You are today making a submission on 6.
Of law will not.
This is not a technicality. This is not the matter here.
Yeah, I will not tell your lord that what is the relief which your lordship can get it. But I think I have, in similar cases where they, like me, in Maharashtra, there was one case where the widow has not paid it, and the court said that to extend that, even in this case, if the court held that even if the dismissal.
No, if it was merely a case of removal, I would have done something and thereby allowing you to file an additional affidavit and bringing on that aspect. That is a different thing. Here it's a case of you are asking for substitution. Yes, your substitution is the meaning is if you continue with the substitution and you win the case, then you will be entitled to all benefits. That is why you have sought for substitution rightly. But if you want to make out a completely different case, then forget about whatever may be. I've been dismissed for so and so for whatever may be, let these orders remain. But then also I'm entitled to the pension or gratuity and all these things. Then it's a completely separate cause of action.
Then, my lord, then, in this case, my lord, I'll then have another look into it. This was the what was reflecting on my mind in the last night, my lord. You'll also give me a short accommodation. I'll try to attack this order on merit also. Put this order of page 98 as well as the capital order, because what I find from the dismissal order is that there is the appointing authority simply says, I found that he has not brought out any new material facts, what is already on record, that I have committed any misconduct, whether my conduct was grave, nothing.
No. Mr. Counsel, prior to, at the time of issuance of the show cause notice, you have submitted a reply, there was an inquiry. You have submitted your statement of defense, there was an inquiry. Pursuant to the inquiry, a second show cause notice was issued to you. When this second show cause notice was ready, you did not bring out anything new which is already not dealt with. And therefore, he passes this order.
Even there are other grounds also which you have taken, that non-furnishing of documents.
That you have clearly said that I have received all the documents as from the records it is seen.
With utmost respect, my lord, I will defer on that point.
When you are saying the records clearly show to that effect, then we can't go into those aspects now.
Your lordship will look into the language in the record.
No, have you received the documents you said the person has said?
Person has
The
said.
record, yes,
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 madam. Yes,
your,
said.
your DR has clearly said it
That
is.
is an aspect of 13 and 14.
You have to understand that the scope of AI is very less, Mr. Kulwa. Huh? You may argue one thing.
Yes.
That as there was no financial loss
Yes, that's right.
to the bank,
Yes.
and the allegations not being proved substantively, it may be at best a case of the bank losing the confidence upon the employee, lack of confidence. And if that be so, it may be a case of removal.
Proposition if it is a bank employee.
So the concept of lack of confidence comes in. So if it is a lack of confidence, it may be a case of removal, and therefore the punishment is disproportionate. And then take it up for the next round for the purpose of getting that once that is done. But with the termination there, the problem arises.
So I have taken the clue from your lordship, but last time when I was looking into the judgment, it says that even if the bank does not suppose, that's a judgment which was against me, that even if the bank does not suffer any pecuniary loss, then also the court will not interfere with
This is lack of confidence, but it may be a case of removal, not a termination, because a termination has more drastic consequences. Try to argue on that point.
Here, see, 14, that criteria they have not fulfilled, because if you say fraud, then you have to put me notice to that fraud. First, There's no allegation of fraud on me, madam.
No, not necessary. That fraud may be, a fraud is, and you need not say that you have committed fraud. You may very well say the circumstances which leads to it, and it comes within the definition of fraud. You have taken money from these persons concerned that we are going to open certain accounts for them and give them agricultural loans. You neither return, neither open the accounts and misappropriated the entire amount. This is the allegation.
But so far that proportionality part, I will again reflect my name. I have taken that view from you also. That is number one. Number two is that if your lordship says that is on the proportionality, that also I will look into it. What I was trying to say is that if your lordship from the totality of the circumstances, if it is a grave misconduct, in one of the judgment I have found that since the appointing authority did not give in the finding that it is grave misconduct, they did not use the word grave, then the Supreme Court interfered. That judgment also I have seen on the last that
It should be.
But suppose if there is only a say that it's a misconduct, the inquiry committee came to a finding that it is only a misconduct. Whereas the rule says it is grave misconduct. If you don't use the word, since the word grave was not interfered, the court interfered with the punishment
Where?
in one of the judges.
Single judge?
Not, I think it's of this. I have taken out the printout of all the judgments. I
Show
just
me
need
one
to-
of that where it is said that you have to mention that grave misconduct. Let us also be enlightened.
Yes. Let me see, madam, because I think it's not right. There's one. Wait. You can also give slightly accommodate me. I can summarize all this and based on the next stage matter. Or because I also don't want to keep this matter pending because so far pension is concerned, even if your lordship gives me the liberty and all, I take this step. Pension, they cannot forfeit if it doesn't fall within rule 14 of the SBI
So
regulation.
therefore,
There are
you have to,
innumerable
that is a separate cause of action.
Yes.
Mr. Dey say, with the moment I allow that Mr. Dey would first of all say that this is not a part of the case at all.
Yes, that was also argued in another case where it was not part of the meetings, but Supreme Court says that since we are upholding the order of dismissal, then those other consequential benefits you have to pay to the widow. Because it is after all a court of equity. And
Supreme Court has such powers under 142. I don't have. No. That power is not there. That if the Supreme Court holds it after that, then the holds of any provision out there, the Supreme Court. In fact, if you see the Allahabad Bar Association judgment also, the Supreme Court, the Constitution bench says, when you are exercising powers under 142, then also you have to be careful it doesn't go again contrary to the law.
Yes.
Now, here the law categorically says that you are going to hear if there is a case of willful neglect as well as fraud. Here the allegation number 2 is a case of fraud.
We'll have to satisfy your lordship.
You satisfy me that allegation 2 is not true.
It is not and
Only that is enough for giving you that relief. For to see, once allegation 2 is not true, allegation 1 is okay, no problem with that. Allegation 1 is no problem, allegation 3 is no problem. But allegation number 2 is a different thing. Allegation number 2 is very disturbing, and for that you have a problem with Rule 14. What do you say, Mr. Dey?
Well, it is not that the 392 document was introduced without notice. Well, there are 59 exhibits.
He also knows. He is making that submission just for the sake of it. He has to make because the earlier council also made that submission.
Everything is admitted, my lord, in the reply, and
No, there's no quarrel with
he
that.
adduced his evidence, my lord. Nothing has been said.
Now, as regards allegation number 2, if he can get hold of allegation number 2, then in that regard,
My lord,
he may take away the question of fraud.
those documents were exhibited by the random
Uh-huh.
signature and without approval, without for creation of STDR, but no STDR register was created. Everything is there, my lord. The documents were exhibited.
Let's see the Supreme Court judgment where it uses the adjective for grave in misconduct.
May I pray?
Misconduct is misconduct. What is there to be grieved about?
Sometimes error of judgment is also not misconduct, madam. But I'll seek for a small, short accommodation on till Friday next, madam. Friday we'll finish up this matter. Your lordship will fix it at 2, subject to your lordship's convenience.
Okay, no problem.
Friday,
But
Friday at 2.
Friday at 2, no problem. So we, by Friday, we will also come to know how many councils are there waiting for other matters to be done. So accordingly, we impose on that day the cost for whose matters would not be taken up on that. No. On the council, not on the widow. Petitioner widow, I am not. I have nothing to that. Because you see, earlier the matter I had taken up on that day, I wanted to finish it off. The council said that let a senior council come and argue. So therefore, I gave the time that okay, let the senior council. Now the senior council says that okay, whatever the earlier council submitted, I'm okay with it, but whatever may be, but don't do this now.
Well, I have seen the the video live stream. Nowadays, we have the facility to watch that video. And this work is pro bono for me, but I have no, this is pro bono for me. I'm just trying to help out this lady in distress. Otherwise, that will see. Last night I was there, but I could not apply my mind fully to all the judgment I have taken out.
You're too busy in doing matters in court number 12.
9.
On 9.
The matter was
So
continued
therefore, you think that the matter need not be done or studied.
on the midnight time till 2 o'clock. I let my junior go off at 2 o'clock yesterday.
Yeah.
But will not, this court is, all courts are equally important to us, but only thing in court number 9, the matter was going on there.
You do one thing.
Yes,
You file an additional affidavit,
yes.
bringing on record these aspects. Once you bring on record these aspects, then we give them a chance to reply.
Yes, I also don't want to take them by surprise.
No, they are not surprised. They also know they won't be surprised. The only thing, if you don't do that, the next thing is an appeal, and the appeal gets, my judgment gets turned down only on that. Whatever the Supreme Court may say. Then the Supreme Court may exercise 142 and say there is no grave misconduct.
Yes. Then, my lord, may I pray on this next Friday on 27, my lord?
Absolutely no. We will have a date on which it is most inconvenient for you. You file the additional affidavit so that we can give them a time to reply. We have to give them because we are bringing this. Heard Mr. B.D. Kumar, the learned senior counsel, assisted by Ms. G.N. Kumar, the learned counsels, appearing on behalf of the petitioner. I've also heard Mr. K.K. Day, the learned counsel, who represents the respondent bank. The learned senior counsel submits that the order of dismissal as well as the appellate order of dismissal suffers from violation of principles of natural justice as well as perversity. This court, however, prima facie is not satisfied with the said submission, taking into account the materials on record. After having perused the materials on record, The senior counsel, however, submitted that irrespective of the findings, as well as the order of dismissal dated the dismissal, irrespective of the findings as well as the order of dismissal, and being confirmed by the appellate order, the petitioner herein, the original petitioner herein, original petitioner herein had already expired. And this court passed an order thereby permitting his wife to be substituted in order to pursue as to whether the petitioners, as to whether the substituted petitioner would be entitled to the pension as well as the pensionary benefits. The learned counsel, senior counsel further submitted, relying upon the State Bank of India Employees Pension Fund Regulation 2014, which was holding the field at the time when did you retire? Were you dismissed prior to that?
I died on 27/7/2020 and retired on Madam just. I was just by the impugn order, so I am dismissed on it.
Which was holding the field at the time when the petitioner was dismissed from service
19/1/2015.
and submitted that by virtue of Rule 14 of the said regulation, the forfeiture of pension would arise in a case, would arise when an employee is dismissed from bank service for willful neglect or fraud. The senior counsel submitted that a perusal of that the forfeiture requires an adjudication. It requires a separate adjudication. And without carrying out such adjudication, merely by dismissing the petitioner, the original petitioner, the respondent bank cannot deprive the family pension to the substituted petitioner.
Legal hands. Legal hands took petitions.
This court have duly perused the writ petition and such, and this very aspect as regards the pension or pensionary benefits and the aspect pertaining to forfeiture of pension as mandated in Rule 14 of the regulations of 2014 are not part of the pleadings. This court also is of the mind, has also taken note of that the incident petition was filed in the year 2017 and it has been pending since then. Further to that, the substituted petitioner is a widow who is nearing 60s. nearing her 60s. And as such, instead of relegating the petitioner to pursue us by way of a separate petition, it is the opinion of this court that the said aspect be permitted to be agitated in the present proceedings by filing an additional affidavit so that the respondent bank would also be in a position to take its stand as regards the new plea being sought to be adopted by the petitioner, substituted petition. First, Mr. B.D. Kuon, the learned senior counsel, submitted that the additional affidavit would be filed within a week's time. First, accordingly, liberty is given to the petitioner to file an additional affidavit on or before 27th of February 2026. This court further grants 2 weeks' time to the respondent bank thereupon to reply. That is on or before 13th of March 2026. That is on or before 17th of March 2026. Uh, 13th of March 2026. You can do it, na? 2 weeks. First. The petitioner further is given the liberty to file a rejoinder to such reply to be filed by the respondent bank within a week's time. That is on or before 23/2026. List the matter on 24th of September, 24th of March 2026 at 2 p.m. for final disposal. It is observed that if the additional affidavit is not filed by the petitioner on or before 27th of February 2026, the present proceedings shall continue in the as per the existing pleadings. Nice. Mr. Sen, what is this? You are for the respondent.
My lord,
I
my lord,
thought
we have
you have
filed,
the petition.
filed our affidavit today, my lord.
Fantastic. Why the Bhagiram Nath? Ah, what has happened? Withdraw his own pension from his own SBI account. Pensioner?
Pre-
Why it is being
Pensioners
kept at
account, my
home?
lord, sub pensioners account, my lord.
Ah,
Now, online fraud has committed, my lord.
how much?
My lord, 19 lakhs, around 19 lakhs something, my lord.
Huh?
We have filed our affidavit with, in this regard, my lord.
How much?
19 lakhs, my lord.
Is it?
Lordship, actually, Lordship, what happened in the account of petitioner, only 12,000 Lordship. And that was in the year 2024. Only single transaction was done.
Where?
Lordship,
Where is your affidavit?
I have received
My lord,
today itself.
Huh? Give it to me. Pensioner, Mr. Sen.
your
If
lordship,
it is
lordship
only
kindly
that
say-
amount of 12 lakh, 12,000, keep a lien on that 12,000.
Moreover, if is ready to pay, if there is such transaction.
Page 26, my lord, annexure A. Is the notice under section 106 BNSS, my lord.
Government, you have made the government a party?
No.
Have you made?
No.
What is wrong? So here 12,000 is there, which happened on
23rd of January 24. It is reflected in your
where?
Annexer B page 420. Six number 22.
This one,
12.
Mongoldoy Bazaar.
Not the budget.
Another one, 11,000.
No.
Why?
Lordship, actually what happened,
No, these are both same.
these are the separate lordship.
Understood. You see,
Lordship, petitioner's account was fees in the month of July, lordship, and the transaction was completed on January, lordship. Since January, they have been transacting, lordship. Petitioner have been transacting, lordship. There is no such.
they received the complaint, then they could learn this.
Lordship.
There are judgments passed by this court, na? Where there is a direction to put a lien.
Only one transaction, moreover, lordship, and the annexer, lordship C. Annexer C petitioner is ready to pay the holding amount.
No, not ready to pay. The thing is, that amount shall not be allowed to be transacted.
Lordship.
Have a lien on that amount.
Lordship.
12,000. What is your age?
64, lordship.
See? Mr. Sen,
My lord,
have a little bit of sympathy.
the coordinate bench of this honorable court passed in order, my lord, keeping lien of
That amount lien will be there. Because you
That
see,
is- that-
after all, some other business, okay.
my
You see, he's a pensioner. One has to be suitable. You have the lien on that. And allow him to. Heard Mr. So-and-so, the learned counsel, appearing on behalf of the petitioner. Mr. B.K. Sen appears on behalf of the respondent number
2 and 3.
2 and 3. Stop. Reserve Bank, that person is there now. What is his name? We served the notice.
My lord, here, my lord, the LHO, my lord, Bhubaneswar, local head office Bhubaneswar has, my lord, frozen the account. On receipt of the complainant from crime branch CID, my lord, Odisha, Bhubaneswar. So it has been frozen, my lord, from local head office Bhubaneswar, my lord. And thereafter, my lord, this branch, Mongoldoy branch, my lord, has been informed. Therefore,
Appears on behalf of the respondent number 2 and 3.
but
Yes.
this LHO, my lord,
Not
Bhubaneswar is not before your lordship.
Not the notice has been sent, they have not received it. It has been served. This court also takes note of the office note dated.
That is, my lord, Reserve Bank of India.
Office note dated 11/12/2023. And the service upon all other respondents have been duly completed. The petitioner herein was a government servant and retired on 31/3/2022. He has maintained a bank account with the State Bank of India, have maintained a savings bank account with the State Bank of India, Mongoldoy Bazar branch, bearing account number 10763 163407. The petitioner, upon his retirement, his pension is being credited to this in this account maintained by the petitioner in the State Bank of India. In the month of September 2024, the petitioner came to learn the petitioner was informed that his bank account, had been frozen on the ground that an amount of rupees 12,000 on 6/7/2024, the petitioner was informed that his account has been frozen on the ground that an amount of rupees 12,000 have been deposited in his bank account. The petitioner submitted representations after representations before the respondent number 2 and 3. Before the respondent number 2,
Open.
Before the respondent number 2, as well as the respondent number 4. That he is facing insurmountable difficulties in view of freezing of his account, in as much as he is not being able to access the dues, access his pension, which is deposited, which is disbursed to the said petitioner's bank account maintained with the State Bank of India. The respondent authorities, however, having not taken any steps, the petitioner have been compelled to approach this court. The record reveals that this court issued notice on 12/11/2025. An affidavit in opposition has been filed by the respondent number 2 and 3. In the said affidavit in opposition, it is mentioned that a notice under section 106 of the Bharatiya Nagarik Sanhita was received from the Odisha police to the effect, Odisha police on 18th of July 2024, to the effect that one Pratap Kesarik Raut had filed a complaint at CID Crime Branch Cyber Crime Police Station regarding fraudulent transaction of rupees 19,41,073.70 from his ICICI Bank State Bank of India and HDFC Bank account by fraudsters on different dates. It was mentioned that an amount of rupees 12,000 was transferred to the petitioner's bank account bearing number 107-631-63407 on 23/1/2024. The respondent number 2 and 3 were therefore requested to take immediate steps to stop and cancel the fraudulent transaction and mark debit freeze account for involved account and to mark debit freeze to various accounts, including the account belonging to the petitioner for involvement in fraudulent transaction and provide current account balance with statement from respective dates till date, along with KYC documents, registered email ID and mobile number of the account holder for taking further legal action at their end. It is further mentioned that on the basis of the said communication, the petitioner's bank account has been frozen. Inasmuch as the petitioner's bank account is characterized under layer 2 of the fraudulent money trail. It is also seen from the said affidavit in opposition that the respondent authorities have, the respondent number 2 and 3 had stated that they are caught between the petitioner's demand for access and the CID's demand for freeze. It was therefore mentioned that until a defreeze order or a no objection certificate is issued by the CID Crime Branch, Orissa, the bank is legally incapacitated from lifting the freeze. Next. This court have duly heard the learned counsels appearing on behalf of the parties and have given an anxious consideration. It is seen that as far back as in the year 2024, and more particularly on 18/7/2024, an email was sent to the petitioner, to the respondent number 3, to the respondent number 2 and 3, by the Odisha police. The transaction, which was found to be disputed, is an amount of rupees 12,000. As would be seen from the very email enclosed as Annexus A series to the affidavit in opposition filed by the respondent number 2 and 3. This court also duly takes note of that the petitioner here is a government servant. And his very access to his pension was a government servant who superannuated. And his very access to the pension is being withheld on account of his account being frozen. This court also duly takes note of that the petitioner had also represented before the Orissa police in the year 2024 itself However, till date, nothing has forthcome from the said Odisha police. There is also no mention that what steps have been taken in the complaint so filed by Pradeep Kesari Raut in respect to those accounts which have been frozen. Though this court finds it very pertinent that for the purpose of investigation, the amount which have been transferred illegally cannot be allowed to be used but at the same time, this court cannot turn a blind eye to the agony of the petitioner for being not able to access his pension. Accordingly, this court therefore disposes of the instant petition with the following observations and directions. The respondent number 2 and 3 are directed to lift the freeze over the petitioner's saving bank account bearing number so and so maintained in State Bank of India, Mongoldoy branch. Branch to naam to chale, Bazar branch. Next. The respondent number 2 and 3, however, shall keep a lien on the amount of rupees 12,000, which was the amount stated in the email dated 18/7/2024 as illegally transferred to the petitioner bank. The petitioner cannot have access to the said amount of rupees 12,000. Next. The respondent number 2 and 3 shall carry out the necessary shall do the needful as directed above within a period of 5 days from the date a certified copy of the order is produced before the respondent number 3. Both of you should have helped me out with that order, and I have to dictate the whole order. And Mr. Sen takes pleasure in troubling this court with this.
Obliged.
What is this?
My lord, this matter pertains to actually, my lord, the contractual dues which the respondents are liable to pay to the petitioners, and to those dues are basically admitted by them. However, my lord, it has a unique characteristic because the institution or the organization from where the petitioner was basically claiming their dues was put under liquidation, was put under insolvency and bankruptcy code, and then liquidation, and subsequently government took over that institution after the organization by the government, my lord. And the government, while taking over the organization, my lord, had made some special arrangement for similarly placed people or persons for giving them their dues. Now, this is a case where we are just seeking parity of treatment because the same persons who are under the similar circumstance were considered by taking cabinet decisions from time to time and were given their dues. My lord, the cases of the petitioners were basically left out. My lord. In just, my lord, this is what the background is, my lord. We are basically seeking a parity of treatment because by an additional package, they have given relief to all the people coming, my lord, from this organization, that is one of Hindustan Paper Corporation Limited, which is
what happened to in NCLT?
my lord,
What happened in NCLT?
my lord, in NCLT, when the proceedings started, my lord, all, as your lordship knows, all the stakeholders were called. We are also some of the stakeholders, like we are the operational creditors, my lord. Now, we as operational creditors, we have submitted our claims from time to time, and our claims was duly acknowledged, which was admitted, and thereafter, my lord, the period under which the insolvency proceeding has to be completed, it is 270 days, however, expired because there was no resolution plan they could come across.
So what they did, my lord, the honorable tribunal closed the, my lord, the resolution process and undertook the liquidation process. Now, even in the liquidation process, my lord, the liquidator who was appointed, he again called for the claims of all the stakeholders. Again, before this liquidator, we have submitted our, my lord, claims, and he has duly acknowledged, and the list was prepared, and it was submitted before the honorable tribunal, that these are the lists among which we are also some of the stakeholders, like operational creditors, my lord. Now, in between, when the process of liquidation was going on, my lord, the government of Assam had entered into the proceedings by giving a proposal to the liquidator that they are willing to take part in the bid process and take over the assets of the Hindustan Paper Corporation, my lord. And in terms of the request made by the government of Assam, the official liquidator then soon put various e-auctions bidding by giving the reserve price of this entity so that they can bid on that reserve price. So the last reserve price, the first reserve price, which was at some 700 crore, came down slowly because there was no bidder forthcoming to 375 crores. Now, my lord, the Assam Industrial Corporation AIDC, through Assam government, bidded for the said amount of 375 crores. Now, the problem now here arises, my lord, when this amount was fixed at 375 crores, now this amount had included the assets of the HPCL in both the two places. My lord, the site which was located in Nagaon and the site which is located in Kachar, and some ancillary, the places, and altogether they have made this amount of 375 crores. Now, with this 375 crores, now there was a part wherein, my lord, there were a lot of liabilities which were already there, like we and the employees, whose, my lord, the share of this liabilities was not taken in 375 crores. So now what government did when the proposal was made, they came out with a plan that we will provide additional packages to all the stakeholders, operational creditors like us, which included the workmen, which included the employees, which included the contractual workers, etc. In that cabinet decisions, our, my lord, the case, we have filed a representation that we are also similar operational creditors. You take our claims as well, but they never responded back. Time and again, we filed our representation, and cabinet decisions came one after another. Finally, the government took a decision that 700 crores additional packages was released, my lord, 700 crores for taking care of these people like employees, the contractual workers, etc. Take care of their requirements, my lord. And these 700 crores was released, and government has conveniently taken care of these people, leaving aside our case, my lord. In this, my lord, why we are before this court, my lord, the government, after filing this representation on one hand, they have never responded. Secondly, my lord, we filed an RDI. Just
Now
signed-
tell me, wait, all these things. When a thing goes for liquidation, or it is done on the basis of a resolution plan, done under 31,
Yes. Liquidation.
it is amount comes down proportionately, whatever the amount it is, it comes down proportionately. Just for example, at the time of liquidation, resolution, what is resolution plan? A resolution plan is a plan where all the creditors being called out, the committee of creditors, they look into it, and thereupon they come up that this is the amount. Just for example, you may be you don't have a first, second, or you may be a third or fourth charge. Taking into account the sequence, the first would be the workers, the second will be the provident fund, the third will be so and so. This is how it is. So you will be 4 or 5, it will come down. Now, the moment you come down to number 4, first they will try to exhaust those proportionately, and some amount will be given, which will be part of the resolution plan. And in the resolution plan, it is given and it is binding upon you. Now, the moment the 270 days is gone, you come to the liquidation. When it liquidation, it happens, whatever the amount is being got out there, that amount becomes the total amount of a purchase made out of the assets and liabilities. It also includes the liability. There is not only the properties, the assets and liability. Now, in that liquidation process, did the government say, or it becomes a part of the record, in that liquidation that we are going to give it.
So they basically come with only a minute.
Later on, the government wants to do favor to somebody and say that we are going to give it. That is another thing. But that is a government being doing whatever maybe, that is another thing. Our state government has got lots of money. They may do many things. But I'm asking you, on the basis of the liquidation process, how do you have a right?
No, Manoj, on the basis of.
On the basis of the cabinet memorandum.
Manoj, on the basis of the liquidation process, Manoj, the amount that is 375 crores, which was the asset they say that they have bought, excluding the liabilities, because liabilities they have taken care of by these additional relief or packages that they have undertaken by taking a meeting with these creditors, not only the financial creditors, but the other creditors, like the operation creditors, like the employees.
No, no, no. Where is the liquidation order?
Manoj, the process of liquidation they have exhausted, and the last email that they have received.
So they didn't go for liquidation.
Manoj,
Was there any liquidation?
Manoj.
So the liquidation must have happened on the basis of, again, tender. Auction.
Auction, Manoj, of course, Manoj.
So once that auction has happened, there must be somebody A, B, C, D
Yes, sir.
who must have participated, and against that somebody has come up with this amount.
Only one bidder has participated, that is government of Assam.
Okay,
There was
so
no
the
other bidder.
government of Assam said that we are going to pay 300 or 375 crores of that. Now, on the basis of that, the proceedings, the insolvency proceedings before the tribunal had closed.
Ended.
Ended. So therefore, this is 375.
Correct.
Now, at the time when they take it, they take also the liabilities.
Yes.
Where is that? Show me that. Do you have a case? Who are you?
Number 5, AIDC.
Then you file your affidavit.
We have filed an affidavit.
What is your stand?
Actually, we have given one-time relief package only to the employees as a
Only to
humanitarian
employees.
grant,
Not others.
not others. Lordship. Because we have been directed by the government of Assam to pay,
That
Lordship.
is what. No? So it will be as per the liquidation order. So liquidation, they must have assessed that this is the amount. So their entitlement would be
Absolutely,
either no or proportionate something. I still remember one case. There's a case pertaining to this. I was doing it when I was a lawyer out there. A huge factory where in Maharashtra, the amount was the loan which was given by HDFC Bank was something around 10 or 12 crores. And in liquidation, they got only 64,000.
Correct, Lordship. Proportionate, they will get.
First, so there is I think the Companies Act 2013 provides how the, what you call, seniority of the claims.
Claims.
What is that provision?
See, which I don't remember exactly, but
Yes, Mr. P.K. Roy Chaudhary. You seem to be the main person to knowing it. Huh?
I don't remember. As we speak, I don't.
Interesting. That case.
I'm sorry, Manoj. Oh, this is the case. Purely, Manoj, we are speaking on the parity of treatment which has been meted out, and from the minor.
No, the parity of treatment, they are saying that they are only giving it to the workers.
Yes, Manoj. They have only considered the other similarly placed incumbents, Manoj. On the ground that it is a humanitarian ground, they have considered. Are we not, Manoj, on the same platform?
No.
No. What?
No, you are not in the same platform because of the saying that you come within the ambit of unsecured creditors.
No, they are also unsecured creditors, Manoj.
No, workers are not. They have the
Actual workers,
first.
Manoj.
Yeah, I will show you where the provision.
I think.
Yeah, where is that? No, not IBC. You will get it out there in the year. IBC doesn't say that. Somewhere it is there in the rules. I forgot how it is to be proportional. Anyways,
Manoj. Manoj,
My only humble submission is now based on the cabinet decision taken by the government of Assam, my lord. The moment they have decided to take over the assets, excluding the liabilities, because the liabilities in this case comes under the special decision they have taken in the cabinet, my lord, and which is at page 284, my lord.
Where?
At
Where
page
does the
284.
284 say? Yes.
Wait,
Where?
annexure 18.
EF gratuity so and so full
284,
payment,
madam.
salary so and so. Government will
Minutes of
provide
18 of-
gratuity and relief to cooperative,
Yes, madam.
cooperative contractual workers engaged not there. Claims of LIC would be given. All categories of employees will, government will provide relief to 24 months for PF. Government will provide permanent jobs to doctors so and so. Where?
No, but they have provided everything to all other, my lord, operational.
Where is yours?
No, that is exactly
You
my
take
case.
it up with the liquidator
Ma-
and say that out of 300 so and so which is there, kindly give me some money.
They have exhausted the funds, my lord.
You see,
Under
the government paid that amount.
Government paid the amount.
See, the government has paid that amount.
Of course, my lord. Government has paid the amount to liquidator after taking the
So
assets.
why you are not taking up with the liquidator?
There's nothing left in liquidator, my lord. The email that we have last received, they have exhausted all the funds. That is what-
So have you not therefore moved the NCLT for that?
My lord, the stakeholders claim herein, my lord, is only in respect of the fact that as the government has.
No, you see, the government is the purchaser. Government is an auction purchaser. Government purchased it with all whatever may be. This is the amount for this, whatever may be, and apart from that, we are going to take care of these people on humanitarian grounds. But as regards your claims, it has to be done by the liquidator. I've never heard of what is you are asking.
That is in fact very unique to this case, man, because at 375 crore, which was 1,100 crore valuation under the insolvency process, came down to 375 crores. So where
That is why I said, 20 crores of HDFC became 64,000. You are only concerned about your case. What I say in the court, you don't hear.
No.
This is how you should have approached the liquidator for the amount. The liquidator, when the liquidator submits the report, where is the liquidator's report? See, Mr. Buragoy.
324.
300?
24. The email that we have received last.
No. Where is the liquidator's report submitted before an NCLT?
That's what
You have to get there. There you will say, he will say that how the amount will be appropriated. The HPCE cannot be the owner of the 375. It is something like this. I tell you what is it, what has happened. As it seems so, I am the owner of a particular plot of land.
Yeah.
Okay. And which is 300 crores, the value. I have liability of around 500 crores. Okay. The government gives me, it goes for liquidation, government, I get it from an auction sale, 225 crores. The liquidator gives me 225 crores. But forgetting that 200 crores is actually due to the others. So what should be there is first the 200 crores has to be exhausted proportionately and 25 crores has to come to me.
Yes, ma'am.
Okay. This is a liquidator's report, which has to be placed before the NCLT. Then you may have a claim. Then
Here,
why are you doing
one moment.
troubling this court with an NCLT? Isn't it, Mr. Henry?
For one moment, my lord, kindly, Lordship, may come to page 326, my lord. There is one email we have received, 326, my lord. 326, my lord, the last. This is the letter, how they have realized and.
Canara Bank, State Bank, proposed distribution of 330.
Admitted position of.
Oh, so and so, Hindustan Paper Corporation contributed 105, so and so. Where's your name?
Hindustan.
Salt Lake Housing. Where's your name?
And our name, Manas,
Where?
Our name doesn't, reflect.
Picture only.
Corporation created,
Process of realization of assets under so and so. So in the line of so and so, so and so, so and so. The undersigned is of the opinion that the creditors of SPC are entitled to following distribution. Total realization 445 crores. Total insolvency resolution 80. Prior payment towards gratuity 0. They have 120. So 120 and this. Then gratuity 1 remand 275. That means I don't understand this. What is this? Come to the 327 the down. Total realization 445. Total towards insolvency resolution cost liquidation 80. Means directly 80 is minus.
80
So
minus
remains 300 so and so. Then
Then
PF is 120.
120.
Then gratuity is 154. So therefore the remaining is
89.68.
89.
Balance available for the proposed distribution.
Now this is being given to Canara
Yes.
Bank. You see Canara Bank's total AR is
43.34.
no, Canara Bank's total admitted is 325.
Correct, madam.
Against that they are getting 43.
43.
State Bank's total is 184.
They are getting
24. 24 months of woman's due, workman's dues, 21. Finished.
Finished.
Then you therefore have to go there. You don't have a case.
They have come up with special packages, my lords.
No. That package. Huh?
If I'm not wrong, 361 and 363.
361, nah?
And settlement of claim of creditors by. official
361. It is given out
363.
there.
363.
Anyway, on Tuesdays and Thursdays, I'm a bit slow
363.
taking into, yes, officially, 361. You see?
363.
Yeah, summary of liquidation, his assets so and so. No, the, and 360?
363, settlement
Ah,
of,
360.
settlement of claim of creditors
Shall
by.
be
official
upon the creditors or they to prove the claim, say the lawyer shall prepare a list. No. What is the sequence? There is a sequence given somewhere. There's somewhere, I forgot. There's a method by which it is to be. Yes, it will first go to the those persons concerned. PF. PF is first. Workers, second. Then this. And do you know that if the government taxes are there, they are the last. So why you are troubling him?
No, we are not troubling anybody, but we are.
No. Your entire reputation is misconceived. Who on earth has given you this idea to file a writ petition before this court?
Because we fall in the category of these.
No.
Editors and the way they have liquidated and have left out.
Sir, withdraw with liberty. Now the liquidator also finished. It's finished because that is the biggest problem when it goes to resolution.
And these people, my lord, are just 11 of just 8 of them. But who has come before this?
Just for example, you see State Bank, the Canara Bank, whose dues is 330 crores, getting only 43 crores. Because the bank dues also come from, has seniority. We don't have a case here. In view of 327, nothing remains. When should we dismiss his petition?
I leave it to your lordship.
Huh?
Sometime maybe.
No. I've heard so many. After this, I think this is no case. It should be dismissed. Should we dismiss it tomorrow at 2 p.m.?
Tomorrow will be difficult.
Eh?
I'm going out of section now, in fact. I'm going out of section now, in fact, after the court. I have some.
Okay, on Friday at 2 p.m.
But let us give an opportunity to at least satisfy lordship on some points.
There's no point to satisfy. This is the very fundamental. It's a very Mr. Buragoy, I never thought that you will make such fundamental. I have considered you to be one of the most brightest counsels of the Gauhati High Court, and now this has happened. Huh? Hey,
Only on
hey,
the
point. Hey, live streaming switch off karo, then I can see. Right. No, 14. 14 zoning, nothing comes here. Here, your matter has ended out there before the liquidator. That is the hard thing. What happens when this is being done? This is no petition is misconceived. That is why the Insolvency Act was made. Earlier, the insolvency proceedings were not properly functioning. It was not doing it. The liquidation under the Companies Act, which was done under earlier 431 to 34 and all, it was not helping anything. It was not happening. It was too. Now, Section 7 coming in the Insolvency Act, it's very nicely. Now, and you see, if you see a particular section, I think in the Insolvency Act, there's a provision also, you're bound by that. You're bound by what is the given out by the NCLT unless you file an appeal against that. And this liquidation report has been accepted by the NCLT. Then how do I say anything that you pay him?
By the arrangement which the government has made, madam, on a very narrow in my.
Government has done on humanitarian grounds to those people who were there. You see, you have Mr. Counsel, you have to appreciate one thing.
Madam,
A due for the government to those workers, the employees out there, they would not receive any pension on all these things. You are a businessman, very well, very rightly so. There are not you. There were many other people who finished off. All these bamboo traders finished. They had huge dues. At one point of time, I was always busy out there in Morigaon to courts doing matters, all suits. All these suits, all bamboo traders have been finished because of this, because of the problem they faced. Yeah. But that is another, besides the point. But the state under no circumstances can be made liable. Isn't it? So when do we dismiss? Okay, tomorrow?
Or, but more will be, difficult because I'm actually going out of station.
You ask him when he wants his dismissal.
Maybe on Friday, madam. Not
Okay.
again for madam.
List the matter having been heard in the entirety. We shall list the matter on Friday at 2 p.m. for dispute.
I'm obliged.
Obliged, Lord.
Till 15, if your lordship allows me to do it on Thursday, some importance is there.
What is that?
My lord, I am a cooperative society. I was given the license for PDS articles. My lord, as per 15.1, there was a complaint against the secretary. Then the Shawama Committee was suspended. Within suspension, there was an interim order in the court that not to take coercive action. They have cancelled the license. Then, my lord, your lordship allows me to file a fresh petition with the liberty. The second petition was filed, while suspension along with the cancellation was challenged. So they, during the pendency, they have withdrawn the revoked the cancellation order, but the suspension order remains. My lord, I have gone through the provision here, and there is a 48-page judgment which I appeared, my lord. It shows that for a particular period, they can remain the suspension. They cannot go beyond the period. So, my lord, within a very short period, this petition can be, not premature, it can be disposed of. Thursday, my lord. At 2 p.m. now, Thursday at 2 p.m.
Very cool. Look. Oh, Friday, I can't. I'm not sitting at 2 p.m. So it will be next Monday, 23rd. Friday, I can't.
Obliged. Your lordship may take my case tomorrow also, man.
No, I see so many other matters are there. Anyways, let's see. Try your luck because you see this bench, we don't know. I am in the midst of a temporary bench of bench 5.
Well,
I'm going to be a bench 4, 5 next week. This week only. I think till tomorrow I'm holding the bench 5, I suppose.
Well, so your lordship may give me a chance to place it before lordship.
No, not tomorrow. Tomorrow, no time. Day after. Okay, day after.
Day after tomorrow. At 2 p.m. I can 15.
May it please your lordship, in item 14, lordship,
Your Lordship may remember that matter, the BTC passed an order, Lordship, in an appeal. Your Lordship has raised a question whether BTC without amending Assam Land Revenue Regulation.
Oh,
That matter, Lordship.
Mr. Mahmood was there.
Yes, Lordship.
Now we are there.
There.
Then
Then a point was raised that I have not challenged the notification. So accordingly, we have filed another writ petition that is pending before division bench. There they have filed an affidavit, Lordship, in opposition and admitted that the bill will have no effect and therefore the BTC cannot exercise its absolute power on land matters. So the assent is by excellency of Governor of Assam assents to the bill, Lordship. It is kept pending, Lordship. So may I pray to list this matter at any date at 2 p.m. to dispose of these matters, Lordship? It means that, Lordship, the order passed by Secretary
1 year
is,
has gone by.
Yeah.
I was taking bench 5 1 year back.
Lordship, it is pending.
Oh.
In the meantime, Lordship, they have challenged the notification in DB 1 year.
Why notification in the division bench?
Because it's a notification purpose.
We have raised that point also, this matter to be listed before single bench as we have challenged a notification, but it was informed that it will be taken by division bench,
Who
Lordship.
said?
Lordship,
Oh,
the
the
court,
court.
yes.
Hello. Let the division bench. Please,
Anything-
we'll take it up some other day. Not the,
Monday.
it's item number 14.
Yes, Lordship. Monday at, Lordship, at 2 p.m., Lordship. At 2 p.m., Lordship, Monday.
Let the matter be listed on Monday.
Lordship.
We'll see how it happens. Because you
Lordship.
see, now it's very difficult.
It's a
to say
hearing
what
matter,
it is.
Lordship.
You see, if I'm not given the motions, then I have no problem. Motions create a lot of problems.
Lordship.
I'll be happy without motions. Then I can
Lordship,
dispose of
Lordship
the.
may record that it may be taken at 2 p.m. Lordship, if motion not complete,
Yes,
then
Mr.
after motion, Lordship, this matter may be taken.
Huh? So therefore, if I don't take motions, it is very good for me. But then I can take up the matters here and the admissions are a lot of there. Hello, take it.
Can it be at 25th? 25th instead of 23rd?
Okay, 25th
At 2 p.m. Lordship.
at 2 p.m.
Obliged, Lordship.